With my lordship, kind permission, my lordship.
ಎಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ನೋಡಿ, ನಮ್ಗೆಲ್ಲ ನಾವು ತೊಳಿಕ್ ಬರೋದು. ಹಾರ್ಟೆಡ್ ಆಗಿದೆಯಾ ನೋಡಿ, ಹಾರ್ಟೆಡ್ ಆಗಿದ್ರೆ ತರಿಸಿ. ಹಾರ್ಟೆಡ್ ಅಂತ ಟ್ರೀಟ್ ಆಗಿರ್ಬೇಕು. ಅಲ್ಲ, ಇದು ಹಾರ್ಟೆಡ್ ಆಗಿ ತರಿಸಿಲ್ಲ, ಬೇರೆ ಯಾವ್ದು ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕು ಆ ಕೋರ್ಟಿಗೆ ಕಳಿಸಿ. ಓಕೆ, ನಾಳೆ ಸೋಮವಾರ ಹಾಕೋಣ. ಮಂಡೇ ನಾಳೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದೆ. ಎಸ್ ಸರ್. ಮಿಸ್ಟರ್ ರಘುಪತಿಯವ್ರು ನಿಮ್ ಹಿಂದೆ ನಿಂತಾರೆ ನೋಡಿ. ರಘುಪತಿಯವ್ರು ನಿಮ್ ಹಿಂದಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ಬೇಕು. ಬರೋ ವೀಕಲ್ಲಿ ಹಾಕೊಂಡು ಏನು ಹೇಳಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ಬೇಕು. ಇಲ್ಲಿಗಲ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ನೆಕ್ಸ್ಟ್ ಏನಮ್ಮ? ಸೇಮ್ ಬಡಿ. ಹಾ, ಆರ್ಡರ್ಸ್ ಇರಿ.
With my lordship, kind permission, my lordship. Seal number 45, my lordship. Matter pertaining to Dharwad bench, my lordship. I appear for petition, my lordship.
45.
Please, my lordship.
2002 matter. 2002 matter.
Please, my lordship. Matter pertaining to Dharwad bench, my lordship. I appear for petition, my lordship.
ಸಾಜು ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ.
ರೆಫರ್ ಮಾಡ್ಬೇಕು my lordship.
ಅಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿಸ್ಬೋಣ.
Please, my lordships.
Registry to, since matter pertains to Harvard bench, it is submitted at the bar that matter pertains to Harvard bench. Come on. The registry is instructed to forward the case papers to the said bench in due course.
Lord, one kind submission, my lord.
If any expenditure is being incurred for this purpose, comma, the petitioner, on being informed by the registry to pay the same in advance, within 1 week from such intimation, failing which this old matter stands rejected on its own. Yes, we incur about 2,000 rupees for sending the papers to benches. Anyway, they will inform you that you have to make the payment. Yes. Next.
Kind submission, my lord. Serial number 29. I am appearing for petitioner. They have filed an application, my lord. I'll have to file objections. My request a week's accommodation in this matter, my lord.
No.
Serial number 29.
No time will be given for filing objections. More than 3 years. Yes, next. Yes.
Fresh matter, serial number 1. Sarada?
Appear for the petitioner in this matter, my lordship. My lordship, this is the petitioner's father is the generalist, my lordship. Under the generalist scheme, is grant BBMP is granted land for this site number 25, my lordship. Out of 50, they allotted site number 25 at the time of the allotment, and they paid that the site upset value of 1,333 rupees.
Sri Hari, Mr. Venkat Reddy, learned panel counsel, is requested to accept notice for respondents.
My
Petitioner
lordship,
to serve copy of the petition.
submission, my lordship, already served the copy of the BBMP, my lordship.
You have served the copy when?
At the time of office objection, they directed to me to serve the copy, and I served the
Give.
BBMP forms in
Give
bank.
one more copy. Give one more copy. Yes. Next.
Lords, I appear for the petitioner, my lords.
Another petitioner to serve copy of the petition along with all the documents on the panel counsel and file acknowledgement in the registry within 1 week, failing which petition stands rejected. Yes.
Lords, page 23, annexure D, my lords, is the first of my representation, which is dated, my lords, 28th of October 2020. My lords, where I had made a request to the response authorities, my lords, to rectify the comprehensive development plan, which shows, my lords, a non-existing road on my private holding. So that application, that representation, my lords,
EGA requested to accept notice for response number 1, emergent notice 2. 1 and 5.
1 and 5.
Emergent notice to the rest.
Mr. Prasad Hegde appears, my lords, for R2.
No,
Very well.
let them choose.
Very well,
I
very
can
well.
say that. Yes. Yeah. Step to be taken. Fourth time. Yeah, have you filed application now? No. All right. 1 week for taking steps in respect of unserved respondent, failing which petition stands rejected. Yes. Same order. 1 week. Remedy. Yes. Yes, ready. Fifth time. By way of substituted mode on the brevet. Steps within 1 week by way of substituted mode, failing which petition stands rejected. Yes, next.
Petition of my
This board.
I remember the petition of my law. The respondent was an address with number 5. We've been serving the respondents, but however, there was an issue with the address. For that, we will take out a paper publication, my lord, and serve them. Sometime we kindly grant the paper publication.
Yes, 1 week granted, otherwise petition stands rejected. Yes.
Grateful.
Yes, brother. This board of as having been withdrawn. Our ಹೆಸರು ತೋರಿಸ್ಬಿಡಿ. You are withdrawing. In terms of memo, which reads as that. Next. 7. What is that office objection, brother? Or who is the office to decide who should be made parties and other things? It's left to the advocates and other side. Yes. Yes, emergent notice. 7, 8, 9. The other. Mr. Gopal Krishna. Same. All. Emergent. Yes. Petition is disposed of as having been withdrawn. A memo hakidralla in terms of memo which reads as under. Liberty as sought for is written. Next. K.K. Vasant. You have given that. Learned counsel for the petitioner has filed a memo. Hakidra? Has filed a memo seeking withdrawal of the petition on the ground that relief sought for has been substantially granted by the answering respondent. First, there is no objection for the request for withdrawal. First, petition is disposed of as having been withdrawn in terms of memo which reads as. Yes.
My lord, IA filed by the respondent or 2 minutes. IA 1/2050.
You are not audible to me. Come here. Peremptory order is there. Yes. IA stands rejected in terms of peremptory order made by coordinate bench on 17/11/2021, which reads as. Yes, sir, argue. 2015 matter. There is a direction by the apex court not to give even 1 day's time.
My lord, kindly pass over, my lord.
Pass over. Only next week, Madi.
Please, my lord.
Next week on request. Finally.
Okay.
Yes. That.
I appear for the petitioner. May kindly see the order sheet dated 29/6/21, my lord.
29/6/21. ಏನ್ ಹೇಳ್ತದೆ ಆರ್ಡರ್ ಶೀಟ್?
ಏನ್ ಹೇಳುತ್ತೆ ಅಂದ್ರೆ ಅವ್ರಿಗೆ 1000 rupees ಕಾಸ್ಟ್ ಹಾಕಿ ಅಬ್ಜೆಕ್ಷನ್ ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಅಂತ ಕೊಟ್ರು. ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲಿವರೆಗೂ ಹಾಕದಂಗಿಲ್ಲ. ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ರೆಡಿ ಇದ್ದೇನೆ.
My lord, in this case, respondent 1 and 2, my lord, cost is paid, my lord.
ಕಾಸ್ಟ್ ಯಾವತ್ತು ಪೇಮೆಂಟ್ ಮಾಡಿದ್ರು?
My lord, cost is paid on. My lord, I have produced the memo and along with receipt also. I may be permitted to come and record, my lord. I will personally come and submit, my lord. Kindly pass it on.
ಅಲ್ಲ, 1 ನಿಮಿಷ, ಇವತ್ತೇ ಬೇಡ, ದಯವಿಟ್ಟು ಇನ್ನೊಂದು ಡೇಟ್ ಕೊಡಿ. ನನಗೆ ಕಾಯೋದಕ್ಕೆ ಇದಾಗತ್ತೆ. ಬಾರ್ಡರ್ ಮ್ಯಾಟರ್ ಇದೆ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
Please.
ಕಂಪ್ಲೈ ಆಗಿದೆಯಾ? Order date, order of the coordinate bench dated 7, order dated so and so made by the coordinate bench 29/6 is complied with. All in first week of June.
Please,
first week after summer vacation. Okay. 1586. Anyway, on request. Okay. ಎಷ್ಟು ಟೈಮ್ ಕೇಳಿದ ಎಕ್ಸ್ಟೆನ್ಷನ್? Extension as sought for is granted ex post facto. First, the submission that the matter is disposed of by the court below is noted. Pass over. Yes. Pass over. Engineer bandagane mention ಮಾಡಿ. I'll take up the matter. Okay.
Number 5 in this matter.
Which?
Ready for hearing. Some of the respondents are not served. Otherwise, I would have 5,000.
Hello. Death evagat. When the death of the respondent happened last year,
Yes.
then matter abates by operation of law.
The application to set aside the commitment.
Ready?
The application to come on record.
And haki, but matter has already abated by operation of law. Even if I do not say it, if you file application, we'll consider.
Usually, right now, I will. It is allowed, my lord, I am ready even for hearing. It is ready, my lord.
Call next week. Call next week. Huh. Application ತಂದಾರೆ. ನೋಡೋಣ ಅದು ಅಪ್ಲಿಕೇಶನ್ ತಂದಾರೆ.
Secondary petition. It was not properly.
I will have this next week on date code. Date code. Should not waste the time of the court in the morning. Yes. ಏನು 1 week ಕೊಡಬೇಕಾಗತ್ತೆ ನನ್ನ ಸರಿ ಏನೇನ ಇರ್ತದವರಲ್ಲ ಆರ್ಗ್ಯೂಯಿಂಗ್ ಕೌನ್ಸಿಲ್ ಅಂದ್ರೆ ತಪ್ಪಿಸ್ಕೊಂಡು ಹೋಗೋದು ನೋಡಿಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಸ್ ಎಸ್ ಅದೇ extension as sought for in the letter, subject letter, is accorded subject to the rider that no further request shall be made. No request for further extension shall be made. Next. Yes, Mohan Chandra. Huh? Another complaint. Padi copy padi. 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 Paso. ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಆಮೇಲೆ ಎಕ್ಸ್ಚೇಂಜ್ ಮಾಡೋದು ಅವರೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ನಮ್ಗೆ ರಿಪೋರ್ಟ್ ಮಾಡಬೇಕು ಅವಾಗ ಅದರ್ವೈಸ್ ನಾಟ್ ಎಸ್ ಹಾ ಏನು ಏನು ಫುಡ್ ಫೀ ಕೊಡ್ಬೇಕು ಅದೇ ವಾಟ್ ಇಸ್ ದಿ ಮ್ಯಾಟರ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಪ್ಲಿಕೇಶನ್ ಕನ್ಸಿಡರ್ ಪಿಡಿಒಗ ಓಟ್ಸಿ ಕೊಟ್ಟು ಬನ್ನಿ ಪಾಸ್ ಓವರ್ ಯು ಓಪನ್ ಫಾರ್ ದಟ್ ಕನ್ಸಿಡರ್ ದಟ್ ಒನ್ ಓಟ್ಸಿ ಕೊಟ್ಟು ಬರ್ಬೇಕು ಆಮೇಲೆ ಎರಡು ಮಂದಿ ಟೇಕ್ ಮಾಡಬೇಡಿ ಅಂತ ಬರ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ ಹೌದಾ ಆಲ್ ಇಶ್ಯೂ ಶ್ರೀ Madam appears for first respondent. First respondent requested to accept notice for first respondent. Panel counsel is requested to accept notice for second respondent. Petitioner to serve copy of the petition on both of them. First time. Adna, you don't type it. Okay. Call this matter next week ಅಂತ ಮಾಡಿ ಟೈಪ್ ಮಾಡೋದು ಬೇಡ ಪೇಮೆಂಟ್ ಮಾಡಿವಿ ಅಂತ ನಿಂಗೆ ಬಂದು ತೋರಿಸಿದ್ರೆ ದೆನ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಯು ಹ್ಯಾವ್ ಟು ಶೋ ಇಟ್ ಟು ದ ಕೋರ್ಟ್ ಆಫೀಸ್ ಎಸ್ this board of has been withdrawn in terms of memo. Same, this board of government advocate hakkoli. Yes. Next. The pass.
make sure that we stitch twice on. Do that in the course of the day. Urgency is because a closure notice has been issued on a petitioner concern. On the ground that there is, actually there are no grounds in the notice, but stating that they are violating the Tobacco Products Act, where there is a separate enclosure where hookah is served. This is a gaming parlor where chess and other activities are organized. Central judgment of the Supreme Court are there, where as long as there is a separate enclosure, there are directions of the Supreme Court not to interfere with the activities. As of now, from February 2022, our place of business has been closed up.
But Tobacco Matters Apex Court said in Health for Millions, the Apex Court said, court should be very, very circumspect in granting the interim orders.
That's right. If I may suggest this, there are two other similar petitions which are again also pending before the Honorable. But I'll give the numbers.
Right.
This will be called on Monday. I'll serve the council for Madam Geeta Devi for the Municipal Corporation. I'll serve
Srimati Geeta Devi, the panel council is requested to accept notice for respondents 1 and 2. Hala? 1, 2, 3. Madam is requested to accept notice for 4 to 7 and 8. 4 to 8. Petitioner to serve copy of the petition along with all the documents on learned AGA and the panel council. All these matters along with so and so. Tuesday. Otherwise, I would have granted. The cigarette is a very serious matter. Yes. Yes. What's the prayer, Sanmesh? The representation. How you are concerned with that? But you are right. You should have a right to have your representation considered. Then read, not otherwise. Interim orders are always inter partes. 1779 judgment of House of Law. Okay. Therefore, how you are concerned with that?
I will see liberty courts to withdraw this fresh petition in case there is any further action. Probably I will have further action to raise a public interest. In case.
Petitioner, having argued the matter for some time and confronted with an unanswerable question as to his having locus standi in the matter, seeks leave to withdraw the petition. Liberty to litigate if a fresh litigable cause of action arises. First, ordered accordingly, and writ petition is disposed of. Every person, Yaro, respondent. State, Madam, this is the person. Yes, sir. Where is Abhinay? Yes, Abhinay, what should be done? In a similar matters, it appears you have made appointment. No? Implementing application allow marna. 29. Yes. ಅಲ್ಲಿ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯನ್ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ರೈಟ್, ಪಾರ್ಟಿ ಮಾಡಿ ಅಲ್ಲಿ ಅಗ್ರಿಮೆಂಟ್ ಗೆ ಯೂನಿಯನ್ ಆಫ್ ಇಟ್ಸ್ ಎ ಗವರ್ಮೆಂಟ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ ಆರ್ಟಿಕಲ್ 299. So it is expressed in the name of the then you have section 21.
On my friend's objection, I made the application for Indian Union of India, the party has regards that has taken steps.
ಇಂಪ್ಲೀಡಿಂಗ್ ಈಗ ಬರಲ್ಲ. ಅದು ಯಾಕೆ ಬರಲ್ಲ ಅಂದ್ರೆ ಇಂಪ್ಲೀಡ್ ಮಾಡೋದಿದ್ರೆ section 21 is a precondition.
On that score, my lord, I have say that notice to the party is sufficient notice to the Union of India, deemed to give notice to the Union of India. So send notice to the party in the arbitration agreement, that is sufficient notice to the Union of India. Jammu and Kashmir High Court in regard to their case itself is considered.
But under Article 299, during my student days, I have read some decisions contrary to the same. There is such a judgment. I may be wrong also. There may be march of law also, which begins from north to south, Kashmir being in the north. Look into, brother. I'll also look into. Face is here. Yes. I'll also look into. Just look into. Call next week. Section 80 CPC notice irata. Hello, I'm asking analogy, I'm trying. Where you seek impleadment, whether in such impleadment where section 80 is mandatory, can there be impleadment without notice? ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಇದಾದ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ಅದನ್ನು ನೋಡ್ಕೊಂಬನ್ನಿ. Okay, on similar lines, because you are saying that 21 is a precondition. 21 matter na call ನೋಡಿ ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್ 20. Yeah. Yes, brother. There was a direction by the court. When direction is there to implead, where was the need for application? Which date direction was given, brother? A coordinate judge bench of this court, by order dated 1/12/2021, had said as under. First, in the light of that, the application in IA number 2/2021 is made, supported by an affidavit seeking impleadment of proposed response number 2. First, the observation of the coordinate judge supports case of the petitioner for impleadment. First, no prejudice will be caused to the other side by such impleadment. First, therefore, application is allowed, and petitioner is permitted to implead the person named in the application as response number 2. Yaru? PDA. Implead PDA. First, Yaru PDA appear Yaru. Professor Lakshmish Rao. Professor Lakshmish Rao is requested to accept notice for the impleaded BDA. Impleaded party, that is BDA. Petitioner to serve a copy of the petition. 2012, brother. Argue the matter. Now we have impleaded. Now tell him come at 2:30. Okay. 2012 matter. Next week ಹಾಕ್ಬೇಡಿ. ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್. ಆ ಡೇಟಿಗೆ ಮಾಡಬೇಕು. Impleading. Implead ಮಾಡಿ. Petitioner has amended the cause title. Open court with leave. Yes, Mr. Patil.
Initiated proceedings in the 321. But the respondent sells the project to the respondent. But now we are challenging the building licenses and the petition filing in the year 2017. Now, despite not giving you notices, construction is still going on. And because petition application filed item number 5.
No, 2017 matter. Building appears to have been completed.
It's on just by the side of Musaman, I'm sure you have a tall building is coming up. I have produced the latest photographs. 321 notice issue I put the law says lots construction should be funded. Because it's concluded. That's the provision of 321. 3 also is issue.
ಅಲ್ಲ 321 ಇತ್ತು ಅಂದ್ರೆ ಹೋಲ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅನ್ನು ಹಾಲ್ಟ್ ಮಾಡೋ ಅಗತ್ಯ ಅಂತ ಬಳ್ಳು ಮಾಡ್ಯಾರ. ಅದು ಎಷ್ಟಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟದ್ದು ಅಷ್ಟನ್ನ ರಿಪೇರಿ ಮಾಡ್ಕೋಬೇಕು.
And area of basement is also enlarged. And what the setback also is violated. In fact, in the lane I think the repetition again.
To appear for whom, madam? For whom your BBMP argue? Stay also has been obtained. 321 final order madidara. Then their appeal in they say it is stayed. Now they are telling the court. Huh? No, where is that stay order? Show me.
The status for the matter, normal my experience.
Not know. What is the interim order? I have to look into that. Today. We can't go by argument whether stay is granted or not. See the order and we decide the matter. But if it is stayed, then matter cannot remain here. If 321 order is stayed, we cannot maintain the writ petition.
We are challenging the license itself. That's pending. Now, this is the development which has happened. Not something. So, first round agi, demand agi.
Where is that interim order? Call. How did you? First.
And in earlier date, the construction.
ಅಷ್ಟು ದೊಡ್ಡ ಬಿಲ್ಡಿಂಗ್ ನಾವು ಸ್ಟೇ ಮಾಡ್ತೇವೆ ಇದ್ದಾಗ ಹಳ್ಳಿಯರ್ ಕೊಟ್ಟೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ ಸೋಮವಾರ ಇಟ್ಕೊಂಡೆ ಅಂತ ಐ ವಿಲ್ ನಾಟ್ ಸ್ಟೇ rains are going to lash. ನೋಡ ಇಷ್ಟ ಅದು ಇಟ್ಸ್ ಹ್ಯೂಜ್ ಪ್ರಾಜೆಕ್ಟ್ ಇರ್ತಾವು ಲೋನ್ಸ್ ಗಿನ್ಸ್ ಕೊಟ್ಟಿರ್ತಾರೆ ಅವನ್ನೆಲ್ಲ ನಾವು ಸ್ಟೇ ಮಾಡೋದ್ರಿಂದ ಬಹಳ ಸಮಸ್ಯೆ ಆಗ್ತದೆ ಆಮೇಲೆ ಡೆಮಾಲಿಷ್ ಮಾಡೋಣ which Supreme Court did in that Pune matter. Let us see. Yes, Ravi Kumar. Call immediately after vacation. Reconsider order dated as 23. Okay, for response.
Yeah, 1 of 20 application.
Call application to enable advocates to come and argue. Consent for parties to come and argue. Yes, Mr. Rupati. Yes. Can we have this after occasion?
Yes.
ಏನು ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ? ಈಗ ವೆಕೇಶನ್ ಬಂತು, ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ಮಾಡಕ್ಕಾಗ್ತದೆ, ಲಾಯರ್ಸ್ ಎಲ್ಲ 4 ಕಾಸು ಬೇಕಾಗ್ತದೆ. Found. ಅಲ್ಲೇ ಈಗ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಆಗಿದೆ ಇಲ್ಲೋ ಅನ್ಕೊಂಡು ಡಿಸೈಡ್ ಮಾಡಿ, ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಆಗಿದ್ರೆ ಎನ್ಕ್ರೋಚರ್ಸ್ ಅನ್ನ ರಿಮೂವ್ ಮಾಡಬಹುದು. ಅರ್ಥ ಮಾಡಿ, ವಿತ್ ನೋಟಿಸ್ ಟು ಎವ್ರಿಬಡಿ. You appear for whom? You also say you are cottoning with government. Eddie. ಇನ್ನೊಂದು ಸರ್ವೆ ಮಾಡಿಕೊಳ್ಳಿ, so that you will have fresh cause of action. You may also come before the court. ಈಗ ಸರ್ವೆ ಮಾಡಿಬಿಡ್ಲಿ, ಇನ್ನೊಂದು ಸರಿ ಬರ್ಕೊಳ್ಳಿ. Shorn of the thickness of the petition book, come on. All the sides having argued the matter vociferously for some time are now in gracious agreement with the suggestion of this court that the list can be put to an end if a joint and comprehensive survey is done with notice to everybody, to all stakeholders, notice to all stakeholders, so that whether there is encroachment as alleged, that there is encroachment as alleged can be ascertained, and if there is one, appropriate proceedings for removal thereof can be taken. First, petition is ordered accordingly and writ petition is disposed of. First, for the purpose of putting the things beyond the pale of doubt, the land inter alia to be measured, surveyed, is survey number 127/2 of Halanath village of Kanakpura Taluka. First, it is open to the all right. It is open to the survey department to seek assistance from the police if need be. IS fell into insignificance. All they go into insignificance. Okay. All contentions of the parties are kept on the work. Okay. Permission for number 6 to enable advocates to come and argue. Yes.
28, Dr. Ray Kalama.
Application. Next week we have difficulty. You call immediately after vacation. Yes, next.
My lord, I am appearing for petitioner. May kindly request a week's accommodation my lord, in this matter.
Your voice is not audible to us. You are quite young,
Lord,
strong.
My lord, may I kindly request a week's accommodation in this matter, my lord?
Yes. Next week. Week after next.
Obliged.
Request of petitioner. Yes. Yes. And what is this amendment?
During the pendency of the petition, a circular was brought to the notice of the petitioner. See that as per that circular, the respondents are permitted to issue a direction to the petitioner. Direct votes in the by 60% of vote to contain the name of the shop. Necessary for that circular to be challenged before the honorable court, which is why we are seeking an amendment. We also seek to bring on record a judgment of the honorable court, which has already decided this issue.
The division bench, which is Malimat's Chief Justice and Mali. Correct. ಅದು ಬೇರೆ ರಾಜ್ಯಗಳಲ್ಲಿ ನೋಡಿ ಅವ್ರ ಭಾಷೆ ಇದ್ದಿದ್ರು ಬೇರೆ ಹಾಕಂಗಿಲ್ಲ. ನಾವು ಅಟ್ಲೀಸ್ಟ್ ಎಲ್ಲ ನಮ್ ಬೇರೆ ಹಾಕೊಳ್ಳಿ, ನಮ್ಮ ಭಾಷೆ ಸ್ವಲ್ಪ ದೊಡ್ಡದಿರ್ಲಿ ಅಂತ ಹೇಳಿದ್ರು. You want to challenge that? What it says?
That we are facing, my lord, that our already have this. It's not 60%, but it is available, my lord. The amendment application has told us.
What the division bench say?
The division bench has said that the Karnataka Shops and Establishments Act is an act that has been enacted to regulate the working and the functioning of shops. The requirement and imposition of rules regarding the code in which their name should be displayed cannot be covered under this act. Therefore, it has been held as ultra-wise. The rule has been struck down, and the consequent respect to penalty has also been struck down.
ಇಲ್ಲಿ ಆ ರೂಲ್ ಅನ್ನೋದರ ಆಯ್ತು. ಕನ್ನಡಕ್ಕೆ ಒಂದು ನಮ್ಮ ಮಾತೃಭಾಷೆ ಅದು.
The only issue why we come to this honorable court is the respondents are coming to the premises and shutting down the shops. They do not have powers to shut down the shops.
ನೀವು ಕೇಳಿ ನಿಮ್ ಕ್ಲೈಂಟ್ ಸಾಲ್ರಿ, ನಿಮ್ ಕ್ಲೈಂಟ್ ಅನ್ನು ಕೇಳ್ಕೊಂಡು ಇವು ಜಜ್ಮೆಂಟ್ ರೂಲ್ಸ್ ಹೆಂಗ್ ಬೇಕಂಗ್ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಇದೊಂದು ಸ್ವಲ್ಪ ತಲೆಯಲ್ಲಿ ಇಟ್ಕೋಬೇಕು ನೀವು. ನಿಮ್ ಕ್ಲೈಂಟ್ ಅನ್ನು ಕೇಳಿ ಕನ್ನಡದಲ್ಲಿ ಬೋರ್ಡ್ ಹಾಕ್ತೀವಿ ಅಂತ ಅವ್ರು ಹೇಳ್ಬಿಟ್ರೆ ಆ ಪ್ರಕಾರ ಪಿಟಿಷನ್ ಮುಗಿಸ್ಬಿಡು. You are entitled to argue on law, but law shows its face always in mask. Okay? ಬೇರೆ ಅನ್ಯ ರಾಜ್ಯಗಳಲ್ಲಿ ನೋಡಿ ಅಲ್ಲಿ ಬಿಡೋದೇ ಅಲ್ಲ ಬೇರೆ ಭಾಷೆಗಳು. ನಮ್ದು ಹಂಗಿಲ್ಲ, ನಾವ್ ಎಲ್ಲರನ್ನು ಇಲ್ಲಿ ಬರ್ಮಾಡ್ಕೊಂಡಿವಿ. ಭಾಷೆ ಒಂದು ಬೋರ್ಡ್ ಹಾಕೊಳ್ಳಿಕ್ಕೆ ನಾವು
it's not 60% and 40%. It is at the same size as the English code. If there's objection raised with respect to this, which is why we have to come before this honorable. Yes, Swami, we produce photographs of this.
ನಿಮ್ ಕ್ಲೈಂಟ್ ಅನ್ನು ಕೇಳ್ಕೊಂಡು ಹೇಳಿ. ಓಕೆ? Yes. Week after next.
Lord, I appeal to the petitioner. In this case, without the bidding is being considered, my lord, after obtaining the sanction plan as per the see, my lord, page 51.
After obtaining
we have obtained the permission, my lord, 50% of percent is also complete. In the meanwhile, what happened was this is in Vijayanagara third stage at Mysore. There was a government order whereby the entire Vijayanagara third stage was brought under the Nagara Sabha City Municipal Council of Vatnali. This is challenged by the Honorable Court, and the instrument is also passed on page 57.
Which is the order now challenge?
Order of challenge is annexed in them. This is in the nature of a provision order, but according to the member, it's a final order.
ತಾತ್ಕಾಲಿಕ ಆದೇಶ ಅಂತಿದೆಯಲ್ಲ
ಅಲ್ಲಿ ಏನಿಲ್ಲ ಈ ಕೂಡಲೇ ಕಟ್ಟಡವನ್ನು ತೆರವುಗೊಳಿಸಲು ಸೂಚಿಸಿದೆ. ಅದಕ್ಕೆ ನಾನು ಈಗ ಫೈನಲ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದನ್ನ ನಾನು ಚಾಲೆಂಜ್ ಮಾಡಿದೆ.
ಅದು ಅಪೀಲ್ ಹಾಕ್ಬೇಕು, ಅಪೀಲೇಬಲ್ ಆರ್ಡರ್.
ಇದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ದಿಸ್ ಇಸ್ ಬೈ ದಿ ಪ್ರಿನ್ಸಿಪಲ್ ಮುನ್ಸಿಪಲ್ ಕೌನ್ಸಿಲ್ ಕಮಿಷನರ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 187(9).
187(9).
Yes, of the Karnataka Municipalities Act.
ಹಂಗೆ ಹೇಳಿದಾರ ಅದರಲ್ಲಿ?
Correct.
ಅಲ್ಲಿ ಅಪೀಲ್ ಹಾಕಿ, ಅಪೀಲ್ ಹಾಕೊಂಡು appealable order 322 appealable order appeal ಹಾಕಿ. ಇದರಲ್ಲಿ ಇಂಟರ್ವ್ಯೂ ಫಸ್ಟ್ ಟೈಮ್ ಬಂದ ನೋಟಿಸ್ ಆಗಿದೆ.
187(9)
ಅಲ್ಲಿ ಹೋಗಿ ಯಾವತ್ತ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ? ಅಲ್ಲ, ನೀವು ಈಗ ಹಾಕಿರ್ಲಿ. ಯಾವಾಗ 21(3) ಬಂದ್ರೆ ಮೋರ್ ದೆನ್ ಎ ಮಂತ್ ಆಯ್ತು. The essential municipalities act, municipal corporation, municipality, adu appealable. Revision 322. Revision wider idea athwa 115 revision type entadu? The challenge is to the orders that are structured on the premise that the building in question is being put up in violation of the building bylaws. That's what building bylaws. First, in fact, they also state that the petitioner is required to take permission from the permission at the hands of City Municipal Council as well, respondent City Municipal Council as well. First. Next. Learned AGA on request appearing for respondent number, first respondent state notifies to the court the provisions of section 322 which provide for revision. First of all, though the word revision is the heading of the section, comma, the text and context of the said provision makes it very clear that it is almost, its scope is almost on par with any statutory appeal. First, next paragraph. In the above circumstances, writ petition is disposed of, reserving liberty to the petitioner to approach the revisional authority, 322 of Karnataka Municipalities Act 1964, for within a period of 2 weeks. First, to enable the petitioner to avail the revisional remedy, alternate remedy comma, the respondents are directed not to implement the impugned orders, not to enforce the impugned orders for a period of 2 weeks. All contentions are kept open. Next paragraph. With the revisional authority, while considering any interim prayer, comma, shall not be influenced by the interim relief, the reprieve granted by this court. All contentions kept open. Yes. Chief Engineer. Huh? Yes. Why they were asked to be here? The construction orders run with the land, not the person. The municipal laws, the corrective orders always run with the land, not the persons at all. Police will do that. Persons, not property. That's right. It can be defeated by like 52 of Transfer of Property Act. To whom notice was issued? Next week you are arguing. ಯಾವ year? 22. Call interim order to continue till next date of hearing. Call this matter on the last week of May, immediately after vacation. Interim order I am continuing. Interim order to. Connected matters idea. Call this matter along with WP number. ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟು ನೋಡ್ಕೊಳ್ಳಿ, ಅದ್ರಲ್ಲಿ ಇತ್ತು ಅಂದ್ರೆ ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಅನ್ನೋದ್ರಲ್ಲಿ ಇನ್ನು ಮತ್ತೆ ಹೆಂಗದು ಹಂಗೆ ಅಪೀರ್ ಆಗಿ ನಮ್ಮ ಮುಂದೆ ಬಂದ್ರೆ ಅಷ್ಟೇ ಬರುತ್ತೆ. ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಅದನ್ನ ಕಾಲ್ ಮಾಡೋದು ಬೇಡ, ಆ ನಂಬರ್ಸ್ ತಗೊಂಡು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ, ಇದನ್ನ ಅದ್ರ ಜೊತೆ ಕಾಲ್ ಮಾಡಿ ಆಫ್ಟರ್ ನೋಟಿಸ್ ಟು ಹಿಮ್. ವಾಟ್ ಹಿ ಸೇಸ್ is just apply your mind. Like in section 52, the list pendants. List pendants and every transfer action list pendants lift agala. Similarly, to every transfer action, a fresh notice need not be issued to the buyer. Anta.
Notice issued is effective because they are not personally on the petitioner.
Petitioner Allah, you are only buyer in original owners.
What they say in the notice is building is your construction in violation of sanction plan. Issuance of notice. That's the sanction declared immediately within 1 month. They issue the notice. How it would be? 3 floors we cannot complete. That is the code of issuing notice. Notice itself is defective. That will not demonstrate.
Last week of May. Next.
Next week.
No. Last week of an urgency. The presence of the engineers is noted. next date, their presence may not be required. Okay. In order to continue. ಹೆಸರು ತಗೊಡ್ಬೇಕಾ ಇಂಜಿನಿಯರ್ಸ್ ಯಾರು ಅಂತ ಹೆಸರು ಅವ್ರದ್ದು ಡೆಸಿಗ್ನೇಷನ್ ಅವ್ರ ಅಕ್ಷರದಲ್ಲೇ ಬರ್ಸ್ಬೇಕು ಅವ್ರ ಕೈಯಿಂದ ಸೈನ್ ಮಾಡಿಸ್ಬೇಕು ಅವರೇ ಹೌದು ಅಂತ ನಾವು ವೆರಿಫೈ ಮಾಡಕ್ ಬರಂಗಿರ್ಬೇಕು ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಯಾರೋ ಒಬ್ಬರನ್ನ ಕೆಳಗಿನವ್ರು ಕಳಿಸಿ ಅಟೆಂಡ್ ಮಾಡು ಕೋರ್ಟ್ ನೋಡಲ್ಲ ಅಂತ ಹೇಳಂಗ ಆಗ್ಬಾರ್ದು ಅದಕ್ಕೆ ಸಿಗ್ನೇಚರ್ ಮಾಡಿ ನಾವು ಇಂಥವ್ರು ನಮ್ ಡೆಸಿಗ್ನೇಷನ್ ಇದು ಕೋರ್ಟ್ ಆರ್ಡರ್ ಪ್ರಕಾರ ಬಂದಿದ್ವಿ ಹಾಜರಿದ್ವಿ ಅಂತ ಹಾಕ್ಬೇಕು ಅದ್ ನೋಡಿ ಒಂದು ಪಾರ್ಟ್ ಆಫ್ ಇದನ್ನ ಮಾಡಿ ಇಡ್ಬೇಕು ಫೈಲಿಂಗ್ ಎಸ್ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನಿಮ್ ಆಫೀಸರ್ಸ್ ಬರುವಾಗ ಬ್ರದರ್ ನೆಗಳೂರು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನಿಮ್ ಆಫೀಸರ್ಸ್ ಬರುವಾಗ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿರ್ತೇವಲ್ಲ ಟು ಬಿ ಪ್ರೆಸೆಂಟ್ ಅಂತ ಅವ್ರದ್ದು ಆಧಾರ್ ಕಾರ್ಡ್ ಜೊತೆ ಬರ್ಬೇಕು ಅವ್ರು ಓಕೆ ಎಸ್ ಅದರ್ವೈಸ್ ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ ಅವ್ರಿಗೂ ಗೊತ್ತಾಗಲ್ಲ ಅಪೋಸಿಟ್ನವ್ರಿಗೂ ಅವ್ರು ಯಾರು ಅಂತಾನೆ ಗೊತ್ತಾಗಲ್ಲ ಎಸ್ ರಾಮಮೋಹನ್ ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ ವಾಟ್ ಇಸ್ ದಿ ಅರ್ಜೆನ್ಸಿ
now they have to give service for broadband service and other connection. Now due to objections raised by the villages and other persons against the petitioner who has got humiliated them. So the annexure L is very clear, my lord. I will read annexure L, my lord. They in page number 59.
Because read the section.
You grammar was put in the grammar.
ಅವರು ತಕರಾರು ಹಾಕಿದ್ರಲ್ಲ ಅವರು ಪಬ್ಲಿಕ್ ಏನು ಅವ್ರು ಹೌ ದೇ ಆರ್ ಅಗ್ರೀಡ್ ಬೈ ದಟ್ ನನ್ಗೆ ಈಗ ನಾಳೆ ಮನೆ ಕಟ್ಟಿಗೆ ಹೋಗ್ಕೊಂತ ನಾ ಹಾಕ್ತೀನಿ ನನ್ಗೆ ಪರ್ಮಿಷನ್ ಕೊಡ್ರಿ ಅಂತ ಇಲ್ಲ ಊರವರೆಲ್ಲ ಬೇಡ ಅಂತ ಹೇಳಿದ್ದಾರೆ ನಾವು ನಿಮ್ಗೆ ಪರ್ಮಿಷನ್ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಕ್ ಬರ್ತದ ಬರೀ ಕರೆಕ್ಟ್ ಅವ್ರು ನಿಮ್ಗೆ ಕೇಳಿದ್ರು ಪರ್ಮಿಷನ್ ಕೊಡಿ ಅಂತ ನೀವು ಊರವರು ಅವ್ರು ಹೇಳಿದ್ರು ಕಲ್ಲಪ್ಪ ಹೇಳ್ದ ಕೊಡ್ಬೇಡ ಅಂತ ನಾವು ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿ ಅವು what he says where are your rules which regulate consideration of the application for grant of permission what it says ಏನಂತಿದೆ ಅದರಲ್ಲಿ ಯಾಕೆ ಗ್ರೌಂಡ್ ಮೇಲೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿ? ಪಬ್ಲಿಕ್ ಅಬ್ಜೆಕ್ಷನ್ ಪಬ್ಲಿಕ್ ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲಿದೆ? Suppose Bill Clinton writes a letter to you, don't give permission for erecting the tower. Will you accept on that? What is why public may object to so many things? It is his property. He knows how to use that property. He is the master of exploitation of the property. Public may say, "Illa neevu city kattikku antara, illa temple kattikku, mattonddu church kattikku." How? What is their right to object? Adeno vote hakkondu permission kottang madak barata. You show how public can oppose. What right is given to the public? That virtually amounts to holding election for every application for grant of permission. ಎಷ್ಟು ಜನ ಎಸ್ ಅಂತಾರೆ, ಎಷ್ಟು ಜನ ನೋ ಅಂತಾರೆ ಅನ್ನೋದ್ರ ಮೇಲೆ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಂಗೆ. That's not the object of law. It is not bound by the popular mandate. It is bound by legal policy content. Please keep quiet. When this is ever taught, when court is in your favor, generally the best wise policy is to keep quiet, unless you want to dilute my view by your substandard. So I am asking a question. That virtually amounts to saying every application for grant of permission should be put to vote of the public and public. ಕಾರಣ ಕೊಟ್ಟು ನಮ್ಗೆ ಬೇಡ ಹಂಗಾಗಿಲ್ಲ ಅಂತ ಹೇಳಕ್ ಬರಲ್ಲ. He is the master of his property. He knows how to exploit it. He wants to build some Qutub Minar there. What is the public having? How they will be aggrieved by this ಅಂತ ಹೇಳ್ಬೇಕು. ಎಲ್ಲಿದೆ? ನೀವು ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ ಮಾಡಿಲ್ಲ. ಮಾಡಿದ್ದು ಗ್ರಾಮಸ್ಥರು ಒಂದು ಪಂಚಾಯತ್ ಮೊಬೈಲ್ ಟವರ್ ಅನುಮತಿ ನೀಡಬಾರದೆಂದು ತಕರಾರು ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸುತ್ತಾರೆ. ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಮಾಡಕ್ ಬರಲ್ಲ. 378 ಸುಪ್ರೀಂ ಕೋರ್ಟ್. That is not the ground. ತಹಶೀಲ್ದಾರ್ ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ. ನೀವು ಮುಂದೆ ಹೇಳಿದ್ದು ಪಬ್ಲಿಕ್ ಆಬ್ಜೆಕ್ಟ್ ಮಾಡಿದೆ ಅನ್ನೋದು ಒಂದೇ ಗ್ರೌಂಡ್. ಅದು ಒಂದೇ ಗ್ರೌಂಡ್ is unsustainable. That amounts to virtually putting every such application to the voting. That is not the ground on which you are rejected. Krishna is knocking at the doors of Writ Court for assailing the endorsement dated 14/12/2020, a copy whereof is at Annexure N, whereby the request for permission to erect a mobile tower in his property has been turned down. The endorsement in the vernacular reads as next. The respondents, having entered appearance through their counsel, oppose the writ petition by filing the statement of objections, contending that the application of the petitioner is not accompanied by the requisites, and therefore the writ petition should be rejected. First, the panel counsel makes submission in justification of the impute order. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter in as much as A. Petitioner happens to be prima facie owner in possession of the subject property. First, ownership is a bundle of rights, and one of them is as to what purpose the property should be put to. If someone discusses at pages so and so, someone jurisprudence discusses so and so, unless the law otherwise restricts. First, the law contemplates a permission for putting up the construction, where the permission is denied on an unsustainable ground, comma, the denial cannot be sustained. On the grounds taken up, dehorse the endorsement as held by the Apex Court in Mohindra Singh Gill versus Chief Election Commissioner, AR 1978 SC 851. 851. Next paragraph. The only reason for denying of the permission for putting up the mobile tower is that the public has opposed such a construction. The application of the kind cannot be treated as requiring a popular mandate. That is not the purpose of law enacting the requirement of permission. The impugned order is contrary to the policy content of the law and the rules promulgated with effect from 29/5/2019. Thank you. First one, in the above circumstances, in the next one. Learned advocates appearing for the respondents seek to oppose the petition on the ground of availability of alternate remedy under section 269 of the municipalities, Gram Panchayat, Gram Swaraj, etc. 93 Act, 1993 Act. First one. Alternative remedy is not treated as a China wall for exercise of writ jurisdiction. Semicolon. It is only a judicially evolved technique which needs to be employed depending upon the facts and circumstances of each case. Semicolon. This case does not admit that the availability of alternate remedy should interdict exercise of writ jurisdiction, the given fact matrix. First, therefore, such a contention is liable to be rejected, and accordingly it is. First one. Next, in the above circumstances, the writ petition is favored. Semicolon. A writ of certiorari shows quashing the endorsement, and the matter is remitted to the panchayat for fresh consideration within a period of 2 weeks. 2 weeks.
ಗ್ರಾಮ ಪಂಚಾಯತಿಯಿಂದ ಅನುಮತಿ ಕೊಟ್ಟಿರ್ತಾರೆ. ಆದರೆ ಸರ್ಕಾರದ ಆದೇಶಕ್ಕೆ ಮೊಬೈಲ್ ಟವರ್ ನಿರ್ಮಿಸುವ ಅನುಮತಿ ಪಡೆಯುವ ಅಗತ್ಯವಿರುವುದಿಲ್ಲ ಎಂದು ತಿಳಿಸುತ್ತಾ ಮುಂದಿನ ಸೂಕ್ತ ಕ್ರಮವನ್ನು ತರಿಸಿ. So the mobile tower is taking any permission. Construction that is on 10/2/2020.
Which is that section which requires permission? 64. It is a structure. What government circular may say so many things. We are not bound by what government circular says. We are bound by what legislature says. Or yes, the payment argument of learned counsel for the petitioner that there is already a government circular, circular dated so and so at Annexure M, which states that no permission is required for erecting the mobile towers, cannot be a ground for circular dated 5/5/2001 or cannot be pressed into service in the teeth of the enacted law, that is section 64 of the 1993 Act. First one. Any section is quoted there? The source of this circular is not forthcoming. Prima facie. First. Yes. All contentions kept up. Yes.
Petitioner is a again, they were awarded a contract as per 7/12/2020 for the
Then what do you want?
I'm requesting for some interim relief.
What is that interim?
The PC is page 55
What is the impugned order date?
order is that
31/12/2021.
yes, I filed it immediately.
Correct. But all this.
Even after request, case management. The Malad PCC only 2 documents for the moment.
Allah, he wants 1 week time. Next week, Kalyananta Mari Bushman.
What happens is,
You want to argue or you want to file the objection? Don't waste time. Next. Call next week.
we request for the upcoming
Next week. Next week. Yes, Akash.
Voting of the house
Pets. This matter was heard by me for some time.
It shows that petitioner entity is a commercial entity.
ಆಮೇಲೆ ಡಿಸಿಷನ್ ಇದ್ವಲ್ಲ ನಮ್ಮ ಹೈಕೋರ್ಟ್ I had told you to look into the division bench judgment. There are half a dozen judgments in PIL jurisdiction. Anyway, it's a commercial activity. Dog breeding is a commercial act, not animal husbandry. It's animal husbandry, still it is commercial activity. ಏನಿದು ಈಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನಿದು?
Page 3 minors. The form 5 minors. The self-assessment has been made.
In respect of this property.
These minors.
ಈಗ ಅವ್ರು ಏನಂತ ಹೇಳ್ತಾ ಇದಾರೆ ನಿಮ್ ಗ್ರೀವೆನ್ಸ್ ಏನ್ ಪಿಟಿಷನ್ ದಲ್ಲಿ?
The grievance is that we being a commercial entity minors. Merely because of the complaint that has been raised by the neighbors, stating that due to the parking of the dogs, there has been a public nuisance that's been created. That minors my entity for some last 2 years.
Maybe.
There was no problem since then. Due to some that was there with the neighbors. All of a sudden, they made a complaint before the DPM. And the DPM asked for an explanation. Along with all the supporting documents. I have submitted all the documents except the CDP, the Comprehensive Development Plan, which is issued only by the DPM. I am not having.
ಅಲ್ಲ ಮಕ್ಕಳಾಗಿದ್ದವರಿಗೆ ತೊಂದರೆ ಆಗತ್ತೆ. ರಾತ್ರಿ ತುಂಬಾ ಮಲ್ಕೊಂಡು ಒಳ್ಳೆ ಸಿಹಿ ನಿದ್ರೆ ಮಾಡುವಾಗ ನಾಯಿಗಳೆಲ್ಲ ಕೂಗಕ್ಕೆ ಶುರು ಮಾಡಿದ್ವು ಅಂತಂದ್ರೆ ಹೆಂಗೆ ಮನುಷ್ಯ ಮಲ್ಕೊಳ್ಳೋದು? Earlier, man himself was in the cave. There was no problem because the dog used to be beside him on his bed also sometimes. But that may constitute any close premise ಇದ್ರು ಅಷ್ಟೊಂದು ನಾಯಿಗಳು ಕೂಗಿದ್ವು ಅಂದ್ರೆ ಜನರಿಗೆ ಡಿಸ್ಟರ್ಬ್ ಆಗತ್ತೆ ಅನ್ನೋದಕ್ಕೆ ಇದು ಮಾಡಿದ್ರು. ನೀವು ಬೇರೆ ಕಡೆ ಎಲ್ಲಾರು ಮಾಡ್ಕೊಳ್ಳಿ. 3 months. 3 months ಕೊಡೋಣ. 3 months ಅಲ್ಲಿ ಶಿಫ್ಟ್ ಮಾಡಿಕೊಳ್ಳಿ. ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಇದನ್ನ ಹಾಕಿ, ಮೆಮೊ ಹಾಕಿ. Within 3 months I am shifting to some other premises. ಹಾಕಿ ನೋಡೋಣ. ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ? BBMP. Notice ಆಗಿಲ್ವಾ? Brother, wait 1 second, wait. Notice ತೊಗೊಳ್ಳಿ. Venkat Reddy, Shri Venkat Reddy, panel counsel is requested to accept Respondents 2.3. ಅಲ್ಲ 1 and 3 ನೀವು ಅಪಿಯರ್ ಆಗ್ತೀವಿ. 1 and 3 GA. ಬಟ್ ಓಕೆ, ಬೇರೆ ಯಾವ್ದಾರ ಇನ್ನೊಬ್ಬ ಹೆಸರು ಹೇಳಿ, ಅದರ ಅಡ್ವೊಕೇಟ್, ಪ್ಯಾನಲ್ ಅಡ್ವೊಕೇಟ್. Pri Venkatreddy, Pramod Chandra. Yes, Mr. Subramani is requested to accept notice for the second respondent BBMP. Or you copy kodi. Call this matter on Tuesday. Or 3 ತಿಂಗಳಲ್ಲಿ ನಾವು ಶಿಫ್ಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಕೊಡಿ. ಸೊ ದಟ್ ನಾ ಇದಾವಲ್ಲ ನಿಮ್ಮಲ್ಲಿ ಅವ್ರು ಬಿಡಿ ಅವ್ರ ಮೇಲೆ. ಟ್ಯೂಸ್ಡೇ ಬನ್ನಿ. Till Tuesday, no precipitatory action shall be taken against the petitioner. This will help you for the vacation.
Lokesh?
Yes. Emergent notice. Forty-one.
Paper. Respondent. Review petition.
Yeah. Call immediately after vacation.
Date fix. Last time disposal matter.
The last week of May 2022.
Date.
Last week. It could have some difficulty. ಯಾಕಂದ್ರೆ ತುಂಬಾ ವೆಕೇಶನ್ ಮುಗಿದಾಕ್ಷಣ ತೊಂದರೆ ಇದೆ. ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜೂನ್ ಅಂತ ಮಾಡಿ. Yes. Yes, Rashmanya.
I am appearing for the petitioner, my lord.
Petitioner.
I am appearing for petitioner.
Come this side.
My lord, this petition is filed seeking stay of the order because without making us the party, they have obtained the orders from this honorable court, my lord. I am representing to the Karnataka State Education Federation is the petitioner. Actually, he is the owner of the premises. They have purchased this property in the year 1985, my lord. My lord, I am produced the sale deed, that is.
You have sold the property. Yes.
Yes.
You are the owner.
Yes, I am the owner of the property, my lord.
No, he says he is the owner. You say you are the owner.
No, my lord. That I have produced the certificate. That what he is claiming, Mr. V. Venkateshaya was the secretary. He was represented on behalf of the federation, my lord. So on behalf of the federation, it is very clear in the sale deed itself. That is a translation sale deed, Kannada to Kannada, that is annexure C, my lord.
Kannada to Kannada translation ಅನ್ನಲ್ಲ ಅದಕ್ಕೆ. ಒಂದು ಭಾಷೆಯಿಂದ ಇನ್ನೊಂದು ಭಾಷೆಗೆ ಇದ್ರೆ ಮಾತ್ರ ತರ್ಜುಮೆ ಅಂತ.
ಅದು ಕಾಪಿ ಮಾತ್ರ ಟೈಪ್ ಮಾಡಿ ಸಾರಿಸಿದ್ವಿ ಸ್ವಾಮಿ. ಅದು
ಟೈಪ್ಡ್ ಕಾಪಿ.
ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕಿದ್ವಿ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಲೇಟ್ ವಿ ವೆಂಕಟೇಶಯ್ಯನವರು ತುಮಕೂರಿನ ಕರ್ನಾಟಕ ಫೆಡರೇಷನ್ ಕಾಲೇಜ್ ಆಫ್ ಎಜುಕೇಶನ್ ಇವರ ಪರವಾಗಿ ಪ್ರತಿನಿಧಿಸುವ ಇದರ ಕಾರ್ಯದರ್ಶಿಯಾದ ಬೆಂಗಳೂರು ಸಿಟಿ ಜಯನಗರ ಅಂತ ಅವ್ರ ಮನೆ ಅಡ್ರೆಸ್ ಕೊಟ್ಕೊಳ್ತಾರೆ ಸ್ವಾಮಿ. ಅವರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿ ಈ ಪ್ರಾಪರ್ಟಿನ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು ಥ್ರೂ ಕಾಲೇಜ್ ಎಜುಕೇಶನ್ ಫಂಡ್ಸ್ ಇಂದ. ಚೆಕ್ಸ್ ಇದೆ, ಎಲ್ಲ ಇದೆ, ಆಡಿಟಿಂಗ್ ಆಗಿದೆ. ಪ್ರಾಪರ್ಟಿ ಆರ್ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಇನ್ ದ ನೇಮ್ ಆಫ್ ದಿ B.Ed ಕಾಲೇಜ್, ಮೈ ಲಾರ್ಡ್.
ಎಲ್ಲಿದೆ
ಅದು B.Ed ಕಾಲೇಜ್ ನಲ್ಲಿ ಅದು ಇದರಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. EC ಇದೆ ನೋಡಿ ಸ್ವಾಮಿ. EC annexure D, my lord. Annexure D, page number 36, my lord. Running page.
36.
Yes, my lord. The Karnataka State Education Federation College of Education ಪ್ರತಿನಿಧಿಸುವ ಕಾರ್ಯದರ್ಶಿ ವಿ ವೆಂಕಟೇಶಯ್ಯ. ಸ್ವಾಮಿ,
ಇಂಥ ಕೇಸ್ಗಳಿಗೆ ಇಲ್ಲಿ ಬಂದು ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕು. ಎಲ್ಲಿ ಒಂದ್ ಕಡೆ ಸಿದ್ದಪ್ಪನ ಗುಡ್ಡದ ಮೇಲೆ ಕೂತ್ಕೊಂಡು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗಲ್ಲ ನಾವು.
So I mean, on the time put I will come personally and also will find synopsis in detail because they are confusing everybody. They are filing lot of cases and lot of petitions to mislead the judiciary also. And presently, this institution is under the aided institution now. Government is running now. Yes, please.
1 second. Was it on the basis of the sale deed?
The suit is pending. The Khata which is standing in the name of my father, who is a dead person, and after the father is dead, the Khata is standing to my mother.
ಅದು ಇದು ಇಲ್ಲಿದೆ ಸೂಟ್ ಡಿಗ್ರಿ ಆಗಿದ್ದಲ್ಲ ಇಲ್ಲಿ ಡಿಗ್ರಿ ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದು ಹಾಕಿದಾರ ಎಲ್ಲಿದೆ ಅದು RFA. OS 2 of 2015 ಅನ್ನೋದು ಒಂದು ನಿಮಿಷ ಅದು ಇದೇ ಸೇಲ್ ಡೀಡ್ ಮೇಲೆ ಸ್ಟ್ರಕ್ಚರ್ ಮಾಡಿದ್ರ ಅದನ್ನ ಎಲ್ಲಿದೆ ತೋರಿಸಿ ಹಂಗೆ ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಡೇಟೆಡ್ ಏನದು I am asking a question. Whether that suit was structured on the sale deed, now he has produced the copy of sale deed, na? Other date, you know? 28/8/1985 sale deed, registered sale deed. Plaint bidi, judge decree, judgment idella, judgmental torsi. Hakidala, please come to page 39. Plaint ಇದೆ. Plaint is filed at page 39. The statement of objections. This is 28/8/95. This is 28/85. Same. Same. So date is wrongly mentioned. Requires consideration. Vacation ಆದ್ಮೇಲೆ ಇಟ್ಕೋಣ. Vacation ಆದ್ಮೇಲೆ ಬನ್ನಿ. You have lost the suit. You have lost the RFA. And now you want to press into service the very same sale deed.
On the technical ground, man. See, Order 7, Rule 11, ನಲ್ಲಿ plaint ಸರಿಗಿಲ್ಲ ಅಂತ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಸರ್. On merit, not on merit, my lord. I will satisfy this honorable court with all the details, my lord. Kindly.
Last week. ಅದು 7/11 ಮೇಲೆ ಆಗಿತ್ತು.
ಹೌದು ಸ್ವಾಮಿ.
ಅಡ್ಜುಡಿಕೇಶನ್ ಎಲ್ಲಿದೆ?
ಹೌದು.
ಅಡ್ಜುಡಿಕೇಶನ್ ಎಲ್ಲಿದೆ? ರೈಟ್ಸ್ ಅಡ್ಜುಡಿಕೇಟ್ ಆಗಿದೆ. ಅದರಿಂದ ಆಗಲ್ಲ. 7/11 ಮೇಲೆ ಹೋದ್ರೆ ಅಡ್ಜುಡಿಕೇಶನ್ ಆಗಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿ 63 ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಅವೆಲ್ಲ ಓದ್ಕೊಂಡ್ಬರ್ಲಿದ್ದಕ್ಕೆ ನಾವೆಲ್ಲ ನಿಮ್ಗೆ ಕಲ್ಸಿ ಕೂತ್ಕೋಬೇಕು ಪ್ರತಿಯೊಂದನ್ನು. ದಟ್ಸ್ ನಾಟ್ ಅವರ್ ಡ್ಯೂಟಿ. ಬರ್ಕಳಿ ಕಾಲ್ ಇನ್ ದಿ first week of June 2022.
I may kindly be estimated.
interim order to continue till then. ಒಂದಾದ್ರೂ ಒಂದು ಡೇಟ್ ಕೊಡಿ, ಔಟ್ ಸ್ಟೇಷನ್ ಇಂದ ಬರ್ತಾರೆ. ನೀವು ಲಾಯರ್ 14%. 6th of June.
For the petitioner, my lord.
Yes.
Yesterday's matter, my lord.
Yes.
Now, respondent, my lord, they have filed one application, my lord, along with the few documents. They have served only today, my lord. No, my lord. My submission is this, my lord. Before
section ಎಷ್ಟದು 69. ಎರಡು ಆಸ್ಪೆಕ್ಟ್ ಇದೆ. ಅಲ್ಲ, ನೀವು ನಿನ್ನೆ ಹೇಳಿದ್ದು ಎಂತ ಕರಿಮಠ, ಕರಿಮಠಗೆ ಯೂನಿಲ್ಯಾಟರಲ್ ಡಿಸಿಷನ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ವಿ. ಇದಂತ ಅರ್ಲಿಯರ್ ಯಾರು ಮಾಡಿದ್ದು? ಫಸ್ಟ್ ಅಲ್ಲೇ ಕಳೆದ 10 ವರ್ಷದಿಂದ ಈಗ ಇಂಡಸ್ಟ್ರಿ ನಡೆದಿದೆ. ಅದೆಷ್ಟಾಗ್ತದೆ ಅಂತ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಈಗ ಹೇಳಿದಾರ ನಿನ್ನೆ 1,60,000 ಕೊಡ್ತಾರೆ. ತಲೆ ಕೆಡಿಸಬೇಡಿ. Yesterday he said that he will make entire payment.
yes, please. I'll do that, man.
Otherwise also you will pay that. But problem ಏನು ಅಂದ್ರೆ, ನೀವು certain allegations you have made that may come in the way, though the period has expired. What is observed therein, you may hold it against the petitioner. It's an industry where workmen are employed, investment from outside, borrowings ಇರ್ತದೆ. Trade license, it's a trade license. ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರೆ, ಫಾಲೋ ಮಾಡಬೇಕು. ಅದನ್ನ ರಿಸಲ್ಟ್ ಅವ್ರಿಗೆ ತಿಳಿಸಿ 2 weeks ಆಗೋ ತನಕ ಯಾವ ಆಕ್ಷನ್ ತಗೋಬಾರ್ದು ಅವ್ರ ಮೇಲೆ. ಆಲ್ರೈಟ್. ಅಂಡ್ ಈ ಕನ್ಸಿಡರ್ ಮಾಡುವಾಗ ಯು ವಿಲ್ ನಾಟ್ ಲುಕ್ ಇನ್ ಟು ದಿ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್. ಇಟ್ ಹಸ್ ಆಲ್ರೆಡಿ ಸ್ಪೆಂಟ್ ಇಟ್ ಸೆಲ್ಫ್. ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಏನೂ ಮಾಡಂಗಿಲ್ಲ. ಮಾಡ್ಕೊಳ್ಳಿ. ಬಟ್ ನಿಮ್ ಉದ್ದೇಶ ಏನ್ ಅನ್ಸ್ಬಾರ್ದು, ಯು ಆರ್ ಗೋಯಿಂಗ್ ಟು ಪಾಸ್ ಅಡ್ವರ್ಸ್ ಆರ್ಡರ್ ಅಂತ ನಂಗೆ ಇಂಪ್ರೆಷನ್ ಕೊಡಬಾರ್ದು. ಅವಾಗ ನಾನು ಕೊಡೋದೇ ಇಲ್ಲ. ಹೌದು, ಇಂಡಸ್ಟ್ರಿ ಅದು ಅಲ್ವಾ? ಇಂಡಸ್ಟ್ರಿ ಎಷ್ಟು ಅಮೌಂಟ್ ಆಗ್ತದೆ ಕೊಡೋದು ಹೇಳಿ. ಅಮೌಂಟ್ ಎಷ್ಟು ಹೇಳಿ, ಅದು ಟೋಟಲ್ ಲೆಕ್ಕ ಮಾಡಿ ಕೊಡಿ. ಪ್ಲಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಎಷ್ಟು ಕೊಡ್ಬೇಕಾಗ್ತದೆ?
ಆಯ್ತು,
ಪ್ಲಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ಬೇಕು.
ಆಯ್ತು,
ಪ್ಲಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಎಷ್ಟಾಗ್ತದೆ ಹೇಳಿ. ಅದು ಕೊಡ್ತಾರ ಅವರು. 12%, 9% ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡಿ.
I will pay.
ಅಲ್ಲಿ ನಿಮ್ಗೆ ಯಾರು ಎಡುಕೇಟ್ ಆನ್ ರೆಕಾರ್ಡ್, ನೀವೇನ ಅಪ್ಲೈ ಹಾಕ್ತೀರಾ? ನೀವು ಮಾಡಿಕೊಡಿ. ಅದು ಪರ್ಮಿಷನ್ ಕೊಡುವಾಗ ಅದ್ರಲ್ಲಿ ಹೇಳಿ ಅದ್ ಏನ್ ಮಾಡ್ಬೇಕು. That's called effluent in industrial jurisprudence. Effluent ಅಂತಾರೆ. ಅದು ಆ effluent ಅನ್ನು ಅವ್ರು ಏನ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋ ಬಗ್ಗೆ ನೀವು ಹೇಳಿ ಅವ್ರಿಗೆ. ಇದನ್ನ ಪರ್ಮಿಷನ್ ತಗೊಳ್ಳಿ ಎಲ್ಲ ಹೇಳಿ. ಪರ್ಮಿಷನ್ ರನ್ನಿಂಗ್ ಇಂಡಸ್ಟ್ರಿ ಸ್ಟಾಪ್ ಮಾಡೋದು. Because running industry, stopping the industry which is running, it's not happy for the society. ಬಹಳ ಜನ ಫ್ಯಾಮಿಲೀಸ್ ಎಲ್ಲ ಡೆಸ್ಟಿಟ್ಯೂಟ್ ಆಗ್ತಾರೆ. ಫ್ರೆಶ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲ, ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ರಿನ್ಯೂವಲ್. ಫ್ರೆಶ್ ಅಲ್ಲ. The petitioner industry is knocking at the doors of Rich Court for assailing the order dated 3/1/2022.
3/1/12 Melo. I'm sorry. 3/1/12 Melo.
Sorry, 3/1/12. A copy whereof is at an excerpt issued by the respondent Grama Panchayat at an excerpt A9 and the consequent endorsement dated 13/1/2012 at an excerpt A11 and A9 are endorsements, both dated 13/1/2012 at an excerpt A11 and A12. First one, the net effect of the impugned orders is the revocation of renewal of license, trade license, and thereby the industrial activity has been interdicted. First, after service of notice, the respondent Gram Panchayat, having entered appearance through its senior panel counsel, has filed a statement of objections. On 2/12/2012, February 2, 2012, opposing the resisting the petition. First, the panel counsel makes a submission in justification of the impugned orders and the regions on which they have been constructed. First, he seeks dismissal of the petition. First, next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant a limited indulgence in the matter as under and for the following reasons. A, petitioner company has running fish and allied in industry stroke business, fish meal stroke the name of fishery related industry since the last a decade or so is evidenced by, is proved by, is prima facie established by the evidentiary material borne out by record. In fact, petitioner was issued the trade license. Yadu initial first one yadu maiden license.
That is my lord 2010 my lord 31/3/2010. Next year my lord M.
Maiden trade license dated
31/3/2010 my lord.
31/3/2010.
Page 172.
Annexer M, Annex M, Brigade Company. The same has been renewed.
On 14/12/2011,
On 14/12/2011, 11 is not in dispute. Bracket ನಲ್ಲಿ ಏನಾಗುತ್ತದೆ
14/12/2011, my lord.
Annexer
2011, my lord, that we have not produced because that the order is, my lord, renewal at the instance of this honorable court. Please.
This fact is evidenced by the very impugned order which rescinds the same. Rescinds the same. First, running of an industry of the kind is not a child's play. Second, it involves huge investment and labor and capital. Huge labor and capital. Huge
And
labor
employment.
First, it also generates employment. Thus, obviously, a few families will be dependent upon the run of the industry. First, the apex court in Excel wave, something like that. Excel where case Excel where industries versus Workmen Excel Air Industries has held that the right to close an industry is not coextensive with the right to start an industry under Article 19(1)(g) of the Constitution. Therefore, whilst interdicting the run of the industry, the stakeholders' interest has also to be protected. This is only to make it clear that halting of a running industry cannot be permitted except by due process of law. The consequences of the opposite proposition are so obvious, and no research is needed for establishing the same. First, next paragraph. As already mentioned above, the petitioner was granted the trade license way back the year 2010, and he got a renewal of the same in the year 2011 and 2012. No, 2012, 2012. First, the industry has been running a decade or so because of the interim relief granted by a coordinate judges of this court. Though sans renewal of license. This should not have happened. It is ideal, but the pragmatics of life are a bit different, and be they as they are. There is force in the submission of senior advocate appearing for the petitioner that grant of license is one thing and renewal thereof is another. The statutory licensing authorities have enormous discretion in the former, whereas its measure is restrictive in the later. Seven. This aspect has not been reflected in the impugned order, which rescinds the license, renewal of license unilateral. License, renewal of license. Okay. This constitutes the first lacuna on the face of the record warranting indulgence of the court. Next paragraph. Though very many contentions are taken up by the respondent Grama Panchayat, all they may not be treated at the hands of this court, since the impugned order apparently has been issued without an opportunity of hearing. So it had enormous civil consequences, like the halting of the industry that has been running with huge capital and labor. Thus, there is a gross violation of principles of natural justice. First, God is also said to have given an opportunity of hearing to Adam and Eve before punishing them for eating the prescribed fruit in the Eden garden, says the Bible. First, if God is to follow the principles of natural justice, there is absolutely no justification for the mortals for not following the same. First, next paragraph. The vehement contention of learned counsel for the panel council for the Grama Panchayat that the industry in question releases a lot of effluents, effluents to the river, Kalina, river, to the river in question, on which the village life depends, can be a ground of regulation, but that per se cannot constitute a sufficient justification for rescinding of the license, renewal of license on an assumptive finding. Next paragraph. The above, next paragraph. Learned counsel for the petitioner, in all fairness, undertook to pay all the arrears of license fees along with penalty and 9% interest, simple interest thereon, as a precondition for seeking renewal of the license. Semicolon. The said undertaking is not only to the respondent Grama Panchayat, but also to this court, so that violation thereof would amount to not only amount to contempt of the court, but would be a sufficient ground for denying the renewal of license. First, he is given a period of 4 weeks to make the remittance. First, next, in the above circumstances, sentence admit. Since the renewal of license that is rescinded has also spent itself, justice of the case warrants permitting the petitioner to make a fresh application for a renewal of license with all requisites. And if one is made, the respondent shall consider the same in accordance with law and in a time-bound way. First, next, in the above circumstances, this writ petition succeeds. This writ petition is disposed of, permitting the petitioner to make an application, appropriate application, along with all the requisite documents and payment of fees, seeking renewal of license, till a decision is taken thereon, and 2 weeks lapse in the event adverse decision is taken, no coercive action shall be taken against the run of the industry in question. All contentions in this regard are kept open. Next, last, it is made clear that the payment of arrears of license fees, penalties, and interest at the rate of 9%, simple interest, the rate of 9% per annum, is a precondition for seeking renewal of license. ಅಲ್ಲಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತಾರೆ ಎಷ್ಟು ಅಮೌಂಟ್ ಕೊಡಬೇಕು ಅಂತ. The respondent Gram Panchayat shall call upon the petitioner to make the payment in writing, whereupon the payment has to be made within 2 weeks. Within 2 weeks, our notice for please. Grateful. So little linguistic changes will happen. Accordingly, I will model that.
Please, grateful.
Serial number 41, I mean.
Serial number
41.
41, Rao Sahab, I have put it in first week of June. First week of June ಹಾಕಿದೆ. ನೀವು ಇರಲಿಲ್ಲ ಕಾಲಕ್ಕೆ ಮಾಡಿದಾಗ ಅದು.
ಇಲ್ಲ ಇದ್ದೆ, ಅದು ನಾನು ವಿಡಿಯೋ ಆನ್ ಮಾಡೋಷ್ಟೊತ್ತಿಗೆ
ಅದು ಆನ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಇಲ್ಲ ಅಂತಾನೆ ನಮ್ಮ ಲೆಕ್ಕದಲ್ಲಿ. ಎಸ್. ನಿಮ್ಮ 44 GS Bhatt. ಎಂತ ಮ್ಯಾಟರ್? Further hearing. Pass over. Can we have it after vacation? Yes. Intimate there, no? Immediately after vacation. First week of June. Start. Okay. Mr. Bhatt, I will release it from Parted. We do not know before whom it comes after vacation. I do not remember also. Release from Parted. Release from Parted. ಗೊತ್ತಾಗಲ್ಲ ಎಲ್ಲರೂ ಅಲ್ಲೆಲ್ಲಿ ಪತ್ಕೊಂಡು not possible. Release from Parted. Is 2002 matter. Harvard. 2011. matter, brother. All 20th on request, reluctantly adjourned to 20th. ಏನ್ರಿ 2000 ಒಂದು ಡಿಕೇಡ್ ಎಲ್ಲ ಆಗಿದೆ. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಡಿಮಾಡೆಡ್ ಟು ಕಂಟಿನ್ಯೂ. Yes, Rudrappa. Running a temple.
Indicated not to show that not to photograph the event. It was not indicating much that it was be conducted. The neighbor, one of the neighbor not noticed a complaint with the corporation saying that they are carrying commercial activity in this settlement. On that basis, not the corporation not issued a notice asking not to public premises. On one hand, they come and see it premises. Subsequently, not and I filed appeal towards standing committee not asking not to come to this stage. Then not and what is marked with standing committee holding that an inquiry not physical merger was brought on 24/8/2012. As such, not there is no merger not given along with the objection stated. Having conducted any merger not or having.
What is the commercial activity? As a chowdhury. Trade license ತಗೊಳ್ಳಿ ಮಾಡಿ ಎಲ್ಲ. Where is power to seize the premises? Power ಇದೆಯಾ? Power to seize. ಯಾಕಂದ್ರೆ ಸೀಸ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ರು ಜಸ್ಟಿಸ್ ದತ್ತು. ಐ ರಿಮೆಂಬರ್ ಹ್ಯಾವಿಂಗ್ ರೆಡ್ ಎ ಜಡ್ಜ್ಮೆಂಟ್. ಇಲ್ಲ, ಯು ಕ್ಯಾನ್ ಪ್ರಿವೆಂಟ್ ಇಟ್. ನೀವು ಪರ್ಮಿಷನ್ಗೆ ಅಪ್ಲೈ ಮಾಡಿ, ದೇ ವಿಲ್ ಕನ್ಸಿಡರ್ ದಿ ರಿಲಿಜಿಯಸ್. ಅಂದ್ರೆ ಈಗ ಮ್ಯಾರೇಜ್ ಅಪ್ಪ, ಮ್ಯಾರೇಜ್ ಸಹಿತ ರಿಲಿಜಿಯಸ್ ಆಗತ್ತೆ. ಯಾವ್ದಾದ್ರು ಮ್ಯಾರೇಜ್ ಮಾಡಿದ್ರು ಅನ್ನೋ ಬಗ್ಗೆ ಪ್ರೂಫ್ ಇದೆಯಾ? ಯಾವ್ದು? ಇಲ್ಲ ಇದೆ, ಎಲ್ಲ ನೋಡ್ಕೊಂಡ ಮಾಡ್ಯಾರ. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಯಾಕೆ ಈ ಕಾರ್ಪೊರೇಷನ್ ನಿಮ್ ಎನಿಮಿ ಅಲ್ಲ? ಕಾರ್ಪೊರೇಷನ್ ಡಸ್ ನಾಟ್ ಕಮ್ ಫ್ರಮ್ ಕರಾಚಿ, ನೇಟಿವ್ ಪೀಪಲ್ ಇರ್ತಾರೆ. Anyway, your contention that you are not, performing any marriages is not true. Otherwise, why they will produce all these things? ಕೊಟ್ಟಿದಾರಲ್ಲ, ಕೈಯಲ್ಲಿ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ನೋಡಿ. ಇಸ್ಕೊಂಡು ಅದೇನು ರಿಟ್ ಜುರಿಸ್ಟಿಕ್ಷನ್ ದಲ್ಲಿ ಅಯ್ಯ ಹಾಕೋ ಅಗತ್ಯಿಲ್ಲ. ಅಲಾಂಗ್ ವಿತ್ ಎ ಮೆಮೋ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಡನ್. 3 and 4 ನಿಮ್ಮ ಮಗ್ಳಲ್ಲಿರೋರು ಅವ್ರಿಗೊಂದ್ 2 ಮ್ಯಾರೇಜ್ ಮಾಡಕ್ ಪುಕ್ಕಟೆ ಕೊಟ್ಟಿದ್ರು, ಅವ್ರು ಅಲೋನ ಮಾಡ್ತಿದ್ರು. ಯಾರು ಅವ್ರಿಗೆ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ? ಚೌಟ್ರಿ ಲೈಸೆನ್ಸ್ ತಗೊಳ್ಳಿ, ಮಾಡಿ ಹಾಕಿ. ಯು ಆರ್ ಟ್ರೀಟಿಂಗ್ ಇಟ್ ಆಸ್ ಎ ಚೌಟ್ರಿ. ಬರೀ ವೇದಿಕ್ ಪಾಠಶಾಲಾ ಆಗಿದ್ರೆ ಐ ವುಡ್ ನಾಟ್ ಹ್ಯಾವ್ ಆಸ್ಕ್ಡ್ ದೆಮ್ ಟು ಇನ್ಸಿಸ್ಟ್ ಫಾರ್ ಲೈಸೆನ್ಸ್ ಅಟ್ ಆಲ್. ಯು ಆರ್ ರನ್ನಿಂಗ್ ಕಮರ್ಷಿಯಲ್ ಇನ್ ದ ಸೆನ್ಸ್ ಫಾರ್ ದ ಪರ್ಪಸ್ ಆಫ್ ಮುನ್ಸಿಪಲ್ ಲಾ ಇಟ್ ಈಸ್ ಎ ಕಮರ್ಷಿಯಲ್ ಆಕ್ಟಿವಿಟಿ. ಪೂಜಾ ಪುರಸ್ಕಾರ ನೀವೆಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ, ಬೇರೆಯವರಿಗೆ ಡಿಸ್ಟರ್ಬ್ ಆಗದಂಗೆ. ಸೀಲ್ ಮಾಡೋದು ಬೇಡ ಅಂದ್ರೆ ನೀವು ಸೀಲ್ ಮಾಡಿ ಅಂದ್ರೆ ಮತ್ತೆ ಮ್ಯಾರೇಜ್ ಕರ್ಕೊಂಡ್ಬಂದು ಮ್ಯಾರೇಜ್ ಮಾಡ್ತೀರಿ. ಅವ್ರಿಗೇನು ಆ ಟೈಮ್ನಾಗ ಮಂಗಳಸೂತ್ರ ಕಟ್ಟುವಾಗ ನಿಲ್ಲು ಅಂತ ಹೇಳಕ್ ಆಗಲ್ಲ, ಅದಕ್ಕೆ ಅದನ್ನ ಕ್ಲೋಸ್ ಮಾಡ್ಯಾರ. ಇಷ್ಟೆಲ್ಲ ಜನ ಅಪಿಯರ್ ಆಗಿದ್ದೆಲ್ಲ ಮ್ಯಾರೇಜ್ ದ ವೈಫ್. That's all right. Pujanu ಮಾಡಬಹುದು. Marriage every day ನಡೆಯಲ್ಲ. All right, ನೀವು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡಿ. ನಾವು ಮ್ಯಾರೇಜ್ ಗಿರೇಜ್ ಯಾವುದು ಪರ್ಫಾರ್ಮ್ ಮಾಡಲ್ಲ ಅಂತ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡಿ. I think give undertaking will dispose of the petition. ಬರ್ಕೊಳ್ಳಿ. Shorn of thickness of the petition book. Essential grievance of the petitioner is against the closure of the structure in question by the officials of the respondent Mahanagara Palike. First, after service of notice, the respondents having entered appearance through their panel counsel opposed the writ petition by filing the statement of objections, wherein inter alia they have contended that the petitioner has been renting out the premises in question for the rituals and activities such as marriages and the like. First, the panel counsel contends that the premises in question is being used as a chowltry, and therefore that cannot be permitted save by obtainment of a trade license as provided under Section 353 of the KMC Act 1976, read with Schedule 10 of the KMC Act 1976, Municipal Corporations and Science. First, next one, having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant a limited indulgence on the undertaking given by the petitioner that the subject premises shall not be used as a chowltry or such other purposes at all. On such assurance given to the court, the respondents are directed to permit the petition, deseal the premises in question, and you have done that. Shall permit the petitioner to use the premises in question for other regular activities in accordance with law, for personal purposes, If petitioner files an affidavit to that effect before the respondents. First, the violation of this undertaking may amount to contempt of this court, in addition to giving a ground for interference of the respondent corporation. Cost made easy. But if you want, brother, if you want to use it as children, you can make application. Liberty is reserved to the petitioner if he so wants, so desires, to apply for appropriate license for putting the property in question to alien use. Under the provisions of BBMP Act 2020. Yes. Under Section 305 of BBMP Act 2020. Okay. 49. Yes, sir. Yes, Dr. Saab.
I was there in the petitioner of 2002. In April 2008, the review petition before the husband commissioner The second was not.
ಎಷ್ಟು 114 ಏನ 14 3 years ಅನ್ನೋದು ಅಷ್ಟೇ. ಇದು rescinding, essentially it is rescinding of khata in review jurisdiction. The short grievance of the petitioner is against the order dated 10/6/2010. Against the order dated 6/12/2012, made by the second respondent at annexure J, whereby the khata standing in his favor has been rescinded in exercise of power under section 114A of the Karnataka Municipal Corporations Act 1976, years after the limitation period for the same has expired. After service of notice, the respondents having entered appearance to the panel counsel oppose the writ petition. Official the corporation of the respondents 1 and 2 having entered appearance to their panel counsel oppose the writ petition. Objection hakira? The panel counsel for the rest, please be seated. The panel counsel vehemently opposes the petition, making submission in justification of the impugned order and the reasons on which it has been constructed. First, he adds that there was some encroachment-like thing, and in that connection, a civil suit was pending between the petitioner and the third respondent, wherein Corporation 2 was one of the defendants. First, next, having heard the learned counsel for the parties, and having perused the petition papers, this court is inclined to grant indulgence in the matter on the sole ground that the state legislature has enacted a bar of limitation of 3 years in section 114 capital A of the 1976 Act. First, the apex court in Sri Uttaradi Math versus Sri Raghavendra Swami Math observed that once the limitation period expires, the substantive jurisdiction cannot be exercised. An argument to the contrary would defeat the purpose of prescribing the limitation itself. It's as rightly contended by learned counsel appearing for the petitioner. First, in the above circumstances, the petition succeeds. A writ of certiorari issues, quashing the impugned order. A writ of mandamus issues to the respondents 1 and 2 to restore name of the petitioner to the khata within a period of 4 weeks, failing which, personally, the incumbents of these offices shall be liable to pay rupees 2,000 to the petitioner per day of delay. First, alinnondu round hakobeku. Learned counsel for the petitioner notifies that the civil suit, the injunctive suit filed by the third respondent in OS number 2006 has been dismissed by the judgment and decree dated 2012. 2012. End date, August 1st. 18/2012, and no appeal is filed against the same, and that the same have attained finality, there being no further challenge thereto. Semicolon. Even this supports case of the petitioner to an extent. Next, in the para, in the A in B mark. Having heard it, para 3 agat, 3A, 3B. Okay. Cost, now no cost. Now, comma, no cost. Okay.
Appear for happy for the respondent. Happy
Yes.
for the respondent. Madam. The
Yes.
lordships have heard this matter the other day. He has encroached
yes.
the conservancy. The lordship suggested to
give up ಮಾಡಿದ್ರೆ ಏನೋ ರಿಲೀಫ್ ಮಾಡೋಣ ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳಿದ್ರು ರಮೇಶ್.
My humble request, I have already removed that conservancy extension, my lord.
ಅದನ್ನ ಗಿವ್ ಅಪ್ ಮಾಡಿಬಿಡಿ, ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡಿಬಿಡೋಣ, ನಥಿಂಗ್ ಸರ್ವೈಸ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್ಸ್ ಅಂತ ಹೇಳ್ಬಿಡ್ತೇನೆ.
ಹೌದು ಸ್ವಾಮಿ, ಅದನ್ನ ಆಲ್ರೆಡಿ ಐ ಹ್ಯಾವ್ ರಿಮೂವ್ಡ್.
Removed and you have given up the conservancy to the corporation.
Yes, my lord. That conservancy lane adjacent to the Prestige Group, my lord. Big building has been constructed, and between Prestige Group building and my property, my lord, that is the conservancy lane they were identified. I have made complaint against the Prestige Group because they have started blasting the foundation, my lord, and it is seriously affected to my building. Therefore, I have made complaint against the Prestige Group. In turn, my lord, the intervener filed a complaint against me with the intention of the Prestige Group, my lord. Now, however, I have removed, my lord, that conservancy lane. It is very clear, my lord. There is no
we'll hold an
any
inspection on this
encroachment.
regard. We'll hold an inspection in this regard,
Please.
but then we will.
Grievance of the petitioner is against the removal orders made under section 320 of the 321 of the Karnataka Municipal Corporations Act 1976. 76. The said order has dated 23/9/2013 came to be affirmed by the appellate authority, Karnataka Appellate Tribunal, in petitioner's appeal 948 of 2013, disposed of on 18/12/2015. After service of notice, the respondents, having entered appearance through their senior panel counsel, opposed the writ petition, contending that the petition is essentially under Article 227 of the Constitution, and therefore the indulgence of the court is very restrictive. Wider sadhana lodh versus so and so. And that the mixed question of law and facts ordinarily are not treated in such a restrictive jurisdiction. First, so contending, he seeks dismissal of the writ petition. Next, having heard the learned counsel for the parties and having perused the petition papers, the impugned order dated 23/9/2013 has been passed by the respondent authorities under section 321 of the 1976 Act. Such orders are founded on some fact matrix which ordinarily will have presumptive value, in the absence of contra being established by cogent evidence, which remains unestablished in the case at hand. First, next paragraph. The challenge to the said order in Appeal 948 of 2013 came to be negatived by the appellate authority under section 444. 443 of the 1976 Act. The said tribunal comprises of a judicial member and a member drawn from the administration, regard being had to the speciality of the fact matrix. Therefore, the interference of this this court, a very strong case has to be made out, as held by the apex court in SP Sampath Kumar versus so and so. 87th Supreme Court. First off, no such case is made out here, either. Next paragraph. The material treated by the authority exercising power under section 321 and the appellate tribunal exercising power under 343 goes to show that the petitioner had encroached the conservancy line, encroached the area up to the conservancy line, which is impermissible. So now it is submitted at the bar that this encroachment is removed. First, next paragraph. In the above circumstances, the writ petition being devoid of merits is liable to be dismissed, and accordingly it is, costs having been made easy. First, the grievance of the petitioner against the others are left open or kept open for being agitated in accordance with law elsewhere. Yes. Yes, next. 2018.
I appeal for the respondent, please, ma'am.
Yes, sir. Yes, sir. Yes.
Has been registered in the
Others, Mr. Bhagwan and others need not wait. Perhaps this matter will consume more time regard being had to its thickness and stature of the lawyers involved. Stature and number. Yes, one or two persons may wait after this matter. Others may not wait. Yes, please. Yes. What is the statement? Make the statement of grievance first.
Grievance now, this 9/11/2009, Khata which has been registered in the name of the petitioner trust, by virtue of the endorsement as per section A, it has been reviewed, and I have been directed to approach the court. In fact, after the Khata, I obtained a license, constructed for 2 years, and constructed a building in the name of the trust. And thereafter, by virtue of the claim of the contesting third respondent, which is in 2014, first time after 2009.
When your Khata was made, entry was made in the Khata in your care. They tell you.
9/11/2009. I have produced property register also.
New property ತೊಗೊಂಡಿದ್ದೆ ಅವಾಗ.
1994. Trust has in 1994.
Trust deed ನಲ್ಲೇ ಬಂತನದು. Trust deed date registered. This property is dedicated to the trust. Then private trust, private trust.
The property was abandoned. Thereafter, the Maratha people, the persons belonging to the formed a trust for And 1994, the register trust came to form, and this property came to be incorporated. This is subject matter of trust deed itself. Now, pursuant to that, what I
1 second. When Khata was transferred in your favor,
Annexure D will not pay 9/11/2009. Annexure D.
9
And property card, that is property register, Annexure C at page 73.
9/11 2009. Property card is given on
Annexure C, same immediately there with the sketch and everything.
tax you have paid.
Yes, I will regularly pay tax. And afterwards, license
Or
construct the community hall. I have obtained license to construct the building was obtained by me on 13/3/2012. Annexure G, I produced. And I was
13/3.
2012, Annexure G.
Ah.
And I was supposed to continue, and I for 2 years.
You have constructed
I
the
have
church.
constructed substantial building, and after 2 years, renewal. I sought for renewal of license.
Is it trade license or construction license? Renewal.
A renewal I sought on 22/2014.
Yake?
License 2 ವರ್ಷ validity.
For commencing the proceeding with the instruction. That's how it is.
Substantial construction has been made by collecting from the community.
Where is that license?
License.
Read. Page number?
Page number 89. Sorry, so what is the license? 13/3/2012. This was also granted.
Where it says within 2 years you should complete the construction. It says, which section says within what time the building should be put up, construction should be completed. Which is that section? How can that be true? Suppose if I want to construct a 100-floor building, it all depends upon the hugeness of the building and nature of the building also perhaps.
In this specific case, the license was granted for 1 year.
Where is that? 1 year ಅಂತಿದೆಯಾ? 1 year whether Mr. Srinidhi ಈ ಲೈಸೆನ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿರಲ್ಲ ನೀವು ಬಿಲ್ಡಿಂಗ್ ಲೈಸೆನ್ಸ್ಗೆ, ಅದು ಟು ಕಮೆನ್ಸ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಪೀರಿಯಡ್ ಪ್ರಿಸ್ಕ್ರೈಬ್ ಮಾಡ್ತಿರೋ ಕಂಪ್ಲೀಟ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಪೀರಿಯಡ್ ಪ್ರಿಸ್ಕ್ರೈಬ್ ಮಾಡ್ತೀವಿ. ಕರೆಕ್ಟ್. ಯಾವುದು ಸೆಕ್ಷನ್ ಏನು?
And commencement certificate was granted on the same date. In the license, it is mentioned as 1 year. Commencement certificate 2 years. Before 1 year, we not have put up some construction. Therefore, we not within 1 year. Before expiry of 1 year, I gave application for renewal of license.
ಅದು ತೋರಿಸ್ಬೇಕು. ಲೈಸೆನ್ಸ್ ಯಾವ ಸೆಕ್ಷನ್ which section says the license shall be valid for a period of Allah. The construction shall be accomplished within a particular period ಅಂತ ಎಲ್ಲಿದೆ ಅಂತ ತೋರಿಸ್ಬೇಕು. ನನಗೆ ಎಲ್ಲಿ ಸಿಗಲಿಲ್ಲ ಅದು ಇಷ್ಟು ದಿವಸ ತನಕ. ಅದಕ್ಕೆ ಇವರ ರೂಲ್ ಬೈಲಾ, ಬಿಲ್ಡಿಂಗ್ ಬೈಲಾಸ್.
License to construct building. Occupation certificate.
occupancy certificate. Within a period of 5 years, you should complete the construction. The construction or reconstruction of building is not completed in 5 years.
Item number 7.
So law says 5 years. So what in your license you will mention depending upon the grease and other things, we do not know. The policy of the state is that within 5 years you should complete the construction. If it is not complete, you should tell the authority, ಇಲ್ಲಿ ತನಕ ಕಟ್ಟೋದಾಗಿದೆ, ಇನ್ನಿಷ್ಟು ಕಟ್ಟೋದಿದೆ ಅನ್ಕೊಂಡು ಸ್ಟಾಪ್ ಮಾಡಬೇಕು. Then fresh question will arise. Therefore, the condition which they have put in is liable to be ignored.
As per Annexure J, on 20/2/2014, I sought for renewal of that license. At that point of time, the third respondent.
Any power to reduce it to a period less than 5 years? Trees and etc. Deliberately, no such discretion is given. Otherwise, the discretion is a commercial, a commodity. That is the reason they have not left any discretion. They have said 5 years. So it's very pragmatic. The availability of sand, funds organized, so many things. And now what happened?
In 1 year, I have sought for renewal of that license. I have constructed substantially. I sought for a renewal of license.
What do you say?
Then, thereafter, after I sought for renewal of license, a third respondent must have another associate form in the same name, earlier saw which is like and they said that this license cannot be renewed. At that stage, they started on the ground that I have not acquired all these questions. Now, ultimately, the property stands in my right from 2009. The announced endorsement as per Annexure A, that is 6 years after my
first license.
6th license must at least register. That is on 21/8/2015. The effect of this endorsement is virtually review of the property name which has been registered in my name, and they are saying the property is allowed to continue in the name of the third respondent, and I am directed to acquire the suite for to work out my rights, including the title.
When the khata was transferred in your favor on 9/11/2009. Our application ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದು? Review of the khata.
I produce their representation very easily.
28/2/15. Where is the power? Under in 14 capital A. Please read. Then how are you going to direct them to go to, let him go to civil court? Where is the civil litigation?
No,
that is not a civil litigation. Read that provision, that condition. What is it? Condition. What is ಸಿವಿಲ್ ವ್ಯಾಜ್ಯಗಳು ಅಂತಂದ್ರೆ ಅದನ್ನ ಆ ರೀತಿ ಹಂಗೆ ಬಂದ್ಕೊಂಡವ್ರು ನಮ್ದು ಅಂತ ಹೇಳಿದ ತಕ್ಷಣ ಸಿವಿಲ್ ವ್ಯಾಜ್ಯ ಆಗಲ್ಲದು. ಎಂತದೋ ಒಂದು ಪ್ರೊಸೀಡಿಂಗ್, ಲೀಗಲ್ ಸೆಂಬ್ಲೆನ್ಸ್ ಇರುವಂತ ಪ್ರೊಸೀಡಿಂಗ್ ಬೇಕು, ಸೂಟ್, ಸಮಥಿಂಗ್ ಲೈಕ್ ದಟ್. civil dispute anta artha, not necessarily suit. There should be something which you can take cognizance of. ಅಲ್ಲಿ ಯಾರೋ ಬಂದ್ಕೊಂಡು ಇದು ನಮ್ದು ಅನ್ಕೊಂಡು ಅಲ್ಲಿ ಕೂಗಿದ್ರು ಒಂದ್ ಕ್ಷಣ ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಆಗಲ್ಲ. ಹಂಗಾಗ್ಬಿಟ್ರೆ ಯಾವ ಬಿಲ್ಡಿಂಗ್ ಅನ್ನು ಕಂಪ್ಲೀಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಯಾರಿಗೂ. Nobody will be safe at the hands of your officers, at least. Who are you? Why you continue? Where is the power to do that? See, there is a registered trustee. Trustee mentions the property in question. You had given the khata in 2009. You have given the property called. In 2015, 12 licenses given, huge structure is built. They have been paying the taxes. One fine day, an association is formed and it comes with a representation. And you invoke 114A without mentioning that one.
Even in such a manner that it is confusing.
Relevant portion ಅಷ್ಟ ಓದಿ, ಅಷ್ಟೆಲ್ಲ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಅದೆಲ್ಲ ಪುರಾಣ ಬರಬೇಕು. ಅಸಲು ದಾವೆ ಎಲ್ಲಿದೆ? OS ನಂಬರ್ ಯಾವುದು? ಅದರಲ್ಲಿ ಏನಾಗಿದೆ? OS
73, please.
94 challenging trust.
Constitution of the trust. Second respondent in my reputation is a Sangha Milord, of which one of the plaintiff is the member of Milord in that Sangha.
All right, shoot, what happened?
That was dismissed
On
what is the trust? Constitution of the trust.
On
That is on 23rd March 2001. Then Arya was filed. That was dismissed and that ended.
Arya
was filed.
Arya number dismissed on
10/3/2005. Persons now found present third respondent. Number 1, Karnataka is one of the members of
Who is the panel advocate? I'll direct removal of his, because he does not know elements of trust law. Who is that advocate who gave that opinion? I will direct them to remove him. No, I do not know whether he has passed the LLB. Trust fact was one of the subjects. The bare, he has not read even bare act of the trust law. Let alone maybe he is appointed on the basis of some caste or political affiliation. Most of the advocates are the same, no? Trust definition, right from the days of Snell on trust, which Mahatma Gandhi used to read. Snell on equity. The Snell on trust says, dedication of property is one of the essentials of a creation of trust. It's not trust that appears in English dictionary. Trust is dedication of property for the avowed purpose. Then trust comes into existence. Without property, no trust at all. There can be an association. Therefore, disclose the name of that advocate. I will direct his removal. No, they will generate litigation. They will generate litigation where we cannot cater to the needs of farmers and the workers, the artisans. ಇಂಥವನ್ನ ಮಾಡ್ತಿದ್ ಕೊಡಕ್ಕಾಗ್ತದೆ. ಇದು ಎಲ್ಲ ಸಬ್ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಇಟ್ಟುಕೊಂಡು ಮಾಡಿದ್ರೆ ಹಿಂಗಾಗ್ತದೆ. ಅವ್ರನ್ನ ತೆಗೆದುಬಿಟ್ರೆ at least mischief will not be there, so that we can use this jurisdiction for better purposes. At 2:30, tell his name. I want to remove him. Let him challenge. Next, 1:30 minutes. Error petition ಹಾಕಿದೆ. I will impose cost, brother. I will impose cost on the commissioner who has done this.
But I appear for the contesting respondent, please, madam.
Yes, tell.
Not kindly see, not annexure A, not the trustee.
Yes.
Not trustee, not it is not the no settler is there. Not nobody has given the property to the trust. Not it is self-declared trust. Not annexure A, page 20 will also kindly see, not for a
But
moment.
it mentions the property. It describes the property. It is a registered trust. You went to the court also.
No.
There was a suit.
No, my lord. That is not correct statement. But in fact, this property belongs to Gosai Mata. But that is totally different. But this trust is created by some group of persons declaring themselves as nobody
How can we decide? How can corporation decide the dispute between you and this one? Especially there is already one decree now.
No. 1 second, Lord. What I am trying to submit is you will ask
come at 2:30.
Pardon?
At 2:30.
Please,
bring Mukherjee on law of trust, so that I can impose cost.
Siddharth Yadav, Mr. Siddharth Yadav, ಮತ್ತೆ ವಿವೇಕ್ ರೆಡ್ಡಿ ಅವರು CMP
53. ಯಾವ ಇಯರ್? 90. ಅಪೋನೆಂಟ್ ನಿಮ್ಮ ಹೇಳಿದ್ರಾ? ಅಪ್ಲಿಕೇಶನ್ ಮಾಡ್ಬೋದಾ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸ್ವಲ್ಪ ಬೋರ್ಡ್ ಹೆವಿ ಇರ್ತದೆ. ನಂತರ ವೆಕೇಶನ್. ಮೆನಿ ಆಫ್ ಯುವರ್ ಫ್ರೆಂಡ್ಸ್ ವಿಲ್ ಬಿ ಮೂವಿಂಗ್ ದ ಅರ್ಜೆಂಟ್ ಬೋರ್ಡ್. ಅಪ್ಲಿಕೇಶನ್ ಸುನೀತಿ ಯಾವುದು? ಏನದು ಇಂಪೆಂಡ್ ಆರ್ಡರ್? The short grievance of the petitioner is as to denial of khata in respect of the subject property, though claim was substantiated by producing necessary documents. Says the counsel for petitioner. Learned panel counsel appearing for the respondent, having opposed the petition vehemently for some time, now graciously agree that he will instruct his clients to have a relook of the matter in accordance with law and in a time-bound way. First, this is appreciated. Next paragraph. In the above circumstances, this writ petition is disposed of, remitting the matter for fresh consideration at the hands of our respondent. The third respondent, we shall hear all stakeholders and decide the matter within a period of 6 weeks. 6 weeks, and inform result of such a consideration to the petitioner as well. Okay. Now, no cause. Okay.
List ಕನ್ನಡ ಬಂದಿದೆ ಸರ್.
ನಿಮ್ಗೆ ಹೇಳಿದವ್ರು ಮಾಡ್ಬಿಟ್ಟು
ಭಗವಾನವರೇ after summarization. ಮೊದಲೇ I'm sorry, I did not know that matter is urgent. Thank you. Thank you. Yes. Put it. Trust matter. Yes. ಹೇಳಿ ಡೆಫಿನಿಷನ್ ಆಫ್ ಟ್ರಸ್ಟ್ ಇದೆ ಅಲ್ಲಿ 1912 ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಓದಿ. ವಾಟ್ ಈಸ್ ಎ ಟ್ರಸ್ಟ್? Tagore law lecture ಅದು? Is it book from Tagore law lecture? Is it Tagore law lecture? Anyway, you do not appear to be very familiar with the books. Yes, Mr. Yadav. Padi. Avri padi. Yes, sir. The property. Therefore, 1912, Justice Dawar, Manek Dawar of Bombay High Court said, there cannot be creation of a trust without dedicating some property. So, property is an essential ingredient of trust, like intent to kill is essential ingredient of offense of murder, culpable homicide, amounting to or not amounting to murder, that way. So property, therefore there is a property which the trust deed of 2094 specifically mentions, number one. Number two, 2009 they have obtained the khata and the property record also has been granted, tax has been paid. In 2012 they have been issued the license, though it said 1 year. That may not be the correct position, with the panel council made it clear. It is for a period of 5 years. When they apply for renewal of the license, all these things have happened. And you have raised a contention. No, this property is not, does not belong to them, etc., etc. How to sustain that? First writ petition challenges renew that like building license. The second one is the endorsement. Does it mention section 114A? No. Yes. Yes. Please come to the crux of the paragraph, that particular matter. Yes. Yes. I have understood. I have read it in Kannada. I have fully understood. Yes. Next. Yeah. Yes. ಅದೇನು ಉಪಯೋಗ ಮುಟ್ಟಲ್ಲ. No, you have read, you asked me to read those pages. I have read. What you want to derive from that reading? You file a representative suit. You file a representative suit. Who is saying that it's a public property? Who is saying that it's a public property? Then everybody should go to the civil court for a representative suit. Yes. They are not selling the property. That's not the issue. Yes. See, we have seen now 4 and 5 we can. Four. It is not your case that it belongs to you. Then constitute subject to suit maranante. Subject to outcome of the suit maranante. That's all. ಅಷ್ಟೇ ತಾಳಿ ಬರ್ಬೇಕು ಏನಿಲ್ಲ ಸುಮ್ಮನೆ ನೆಸೆಸಿಟಿ ಏನಿಲ್ಲ ಬರ್ಕೊಳ್ಳಿ. These two writ petitions ಏನಾರ ಸಬ್ಸ್ಟ್ಯಾಂಟಿವ್ ಸಬ್ಮಿಷನ್ ಇದ್ರೆ ಮಾಡಿ. ನಾನು ಸುಮ್ಮನೆ ಸೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಓದ್ಬೇಡಿ. I can read them even during night time also. I read all now. I have no other work now, being arrested at home. Even otherwise. Therefore, I work, I read like anything, to be frank with you. Therefore, do not waste time. Good. Deed. It's a registered deed.
They got it registered. After lapse of 660 days, they have kept quiet. Nobody was aware. Only 20.
When your society was registered? Does it, whether your bylaws mention this property to be of Sangha? Properties of the Sangha. Any standard format relating to trust, the association deed will have that clause. Why?
Along with the regarded to subjection, because first time for Eastern
2015, 13.
Yes, 13. He is referring to some other association which was not taken or it superseded when he constituted the trust. Because not the Karnataka people constituted a gathering, and then they said not trust that we formed. Because the earlier people had sold certain properties. Then in 1994, this trust was.
Because this property is mentioned in your 72 association. And what is your case? Your case. You are a tall advocate, both in terms of physique and stature. Is nobody disputes that. Everybody agrees with that. But you can't make a short case taller by your argument. You admit that your 1972 memorandum of association does not mention this property. Suppose if I say something that may prejudice your case suit which you are fighting, instead, as a concession to you, I say I will dispose of this writ petition, saying that the endorsement to be invalidated, entry to be restored to them, and subject to outcome of the suit which you are fighting. That is what you have stated in your suit also. You happen to be one of the plaintiffs there. I've seen that. You are not one of the. Torsi. Of them.
And Lord first linkage, he is the present Lord Assistant Secretary, Lord constituted as 1913 document. Annexion Lord that I have produced.
So he was that he was a party in a sense.
And Lord Ganesha, who was supposed to be affiliated now as the secretary of this Sangha, constituted in 13. His father was the relative number 2.
In that suit.
In that suit. The same set of people that have constituted in 2020. In 2012, I filed an application. There was a notification for.
All right, 2013 association dalli ಈ ಪ್ರಾಪರ್ಟಿ ಅಸೋಸಿಯೇಷನ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಎಲ್ಲರ ಮೆನ್ಷನ್ ಮಾಡಿದ ತೋರಿಸಿ ಅದನ್ನ ಹೇಳ್ತಾನೆ ಆಮೇಲೆ ನಾನು ಕೇಳ್ತೇನೆ. You have to satisfy the court. Show me in your association where you have mentioned this property as belonging to the association.
Along with it.
What do you? But ಅಂತ ಯಾರು ಎಲ್ಲಿ ಹೇಳಿದ್ದಿದ್ದು? 7, 8, ಯಾವ section 90 of it's like injunctive suit. Finding is presumptive finding. It's an injunctive suit. Dismissed. Suit is dismissed. It was not a representative suit. Such a finding, even if it is assumed to be, the Supreme Court has said it cannot be treated as a finding in rem at all. There is such a judgment. Anyway. Petitioner, a registered trust, is knocking at the doors of Writ Court for assailing, grieving against deletion of its name from the property records and denial of renewal of building license. On the assumptive finding that our respondent is no? The third respondent, the respondent at the Hesreli. The respondent Maratha Samaj Gosavi Mat is the owner of the subject property. First, by the impugned endorsement, the petitioner has been asked to approach the civil court for establishing its title to the subject property, and only thereafter to seek reinstatement of its name in the property register and the grant of renewal of building license. First, the corporation has entered appearance through its panel counsel, opposes the writ petition. Similarly, the respondent Samaja, having entered appearance through the learned senior advocate, vehemently opposes the writ petition. First, having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter as under and for the following reasons. A, the subject property is comprised in the registered trustee dated 18/7/1994, a copy whereof is at annexure at annexure B. Nimdralu Bina A/B. B stands prima facie established by its perusal. Seven, full stop. In pursuant to the registered trustee, the entries in the property records came to be mutated in favor of the petitioner trust on 9/11/2009, and consequently, a property card also has been given. Taxes are paid. The petitioner trust obtained a building license on 13/3/2012 and has started putting up building a community hall, a community hall, and a temple as well. All this is established prima facie by the material placed on. Next paragraph. The building license dated 13/3/2012 had prescribed a period of 1 year for accomplishing the construction, and the construction having not been accomplished accordingly, a request was made for issuance of a renewal of building license. The said request has been denied pursuant to the endorsement dated 28/3/2014, wherein the corporation, respondent corporation, on the thoroughly erroneous legal opinion furnished by its panel advocate, occasionally name not stated. We are not stating. Name left unstated for obvious reasons. Removed the name of the petitioner trust from the property records, and in its stead entered that of the respondent Samaja. First, I'll come. In the meanwhile, on the same premises, the request for renewal of building license was also denied. Then first sentence is correct.
No, first sentence is not your that is right. Radha is cancelled. This will be not renewal.
21/8.
Cancelling by date.
Denial of renewal.
28/3/14.
Sentence. Next paragraph. Second paragraph. Next one. When the building was not accomplished, having not been accomplished, phrase it. Having not been accomplished, the petitioner had sought for renewal of building license, which came to be denied by the order dated 28/3/2014. First. Subsequently, an endorsement came to be issued on 21/8/2015 to the effect that the petitioner is not the owner of the subject property, and the respondent Samaja happens to be the owner, and therefore name of the Samaja to be entered to the property records till after petitioner obtains a decree from the civil court in its favor. First, this endorsement has been constructed on a thoroughly wrong legal opinion of the local panel advocate, which is mentioned in the very endorsement itself. First, the same is contrary to the rudiments of law of private trust. In fact, had the panel advocate seen the first 3 sections, he would not have given such an opinion at all. First off, much can be said about the inefficiency of the panel advocate, However, this court refrains from doing it for obvious reasons. Next paragraph. It has been settled by the apex. It has been a settled position of law that the local bodies have to act upon the registered instrument conveyances and instruments with a presumptive value. Wide 1986 Supreme Court. Punjab 86. Right. In fact, accordingly, the local body had acted upon the same and entered the name of the petitioner to the property registers, had granted the property card, had received payment of taxes, had issued building license. That being the position, all of a sudden, the local body turned around completely in violation of the settled legal position and asked the petitioner trust to approach the civil court for establishing its title. First, there was absolutely no material or such an volt of essay in the given case. Next paragraph. What bewilders this court is the conduct of the respondent local body in issuing the building license dated 13/3/2012, stipulating a condition that the construction should be accomplished within 1 year, when the law permits 5 years. Why the regulation, building bylaws, BBMP building bylaws 5 or 4.1%? Not 4.1. 4.1 is consideration. Shumaga. Shumaga. BBMP. Building bylaws. Building bylaws. BBMP building bylaws. To them also applicable. How? These building bylaws are done by the Mahanagar Palike. What are your building bylaws? That's all right. License building should be, construction should be accomplished in a particular period. Anta yavdu nimma law helodu? 306, sir. Does it speak of commencement or accomplishment? Only commencement. Then why do you say it should be 1 year? For commencing 1 year. For completing, there is no period prescribed. Huh? If it is not acted upon me, Justice Swami has held, if you do not start construction that way, where is the period for lapse once they construct? They start construction. Where is the... No, I have that 306 with me. Lapse of permission if not acted upon within 2 years. Acted upon means if you do not start, Budli Puja start madledre. Ado maadi adamele ಎಷ್ಟು ವರ್ಷಕ್ಕೆ ಕಟ್ಟಬಹುದು ಅನ್ನೋದು question. Whether there is any prescription like 4.1 here in BBMP. You are not assisting Mr. Panel Counsel. I want to ignore that unless it is shown that for stipulation there is legal empowerment.
So building bylaw 5.2 says about 2 years.
Shumaga.
No, my lordship, BBMP only, my lordship.
Shumaga now. BBMP is very clear. You have got rules here. That prescribes 5 years. Commencement is within 2 years.
2 years.
Completion within 5 years. Then completion certificate should be furnished then occupancy certificate should be obtained. That is how the scheme of the bylaw is. But for your corporation, bylaw sila. Parkali. 306 is minimum it will be 2 years because we can act upon within 2 years. That's how. You're right. Okay. It is ununderstandable as to how a condition of 1 year for accomplishment of construction of such a huge building was stipulated when Section 306 of the KMC Act 1976 itself indicates that the period cannot be shorter than 2 years. That is how the section is structured. First off, this finds support from the commencement certificate dated 13/3, evenly dated at Annexure K in Gopal or Gopal in WP number, in companion WP number. So and so. It stipulates 2 years in so many words. First, despite repeated request, no law is brought to notice of this court, which enabled the local body to stipulate a period less than 2 years. Less than 2 years. First, similarly, no law is brought to my notice that there is any specific period within which the construction should be completed. 7. That being the position, a condition which is stipulated without authority of law is liable to be ignored by the writ court. 7. If that is done, the question of petitioner seeking renewal of license and request for renewal being turned down, all will fall into insignificance. First, the maiden building license itself would renew to the benefit of the petitioner, going by the tenor of law. Next paragraph. There is yet another grave error in the impugned endorsement, which drives the petitioner to the civil court for the redressal of the grievance imagined by the local body when petitioner himself had none. There was a civil suit in OS number 106/1994 concerning the subject property, and that was dismissed by the jurisdictional court on 23/3/2001. First off, even the appeal in RA number 11/2001 against the dismissal decree was also turned down on 10/3/2005. This is not reflected. Whatever on the ground of maintainability, on grounds, on merits. All right. In fact, there is a discussion in the trial court's judgment about the registered trustee of the petitioner. First, this is not reflected in structuring the endorsement, nor in denying renewal of building license to the petitioner. First, next paragraph. The vehement submission contention of learned senior advocate appearing for the respondent Samaja that in the judgment dated 23/3/2001, learned trial judge has mentioned about the title of subject property lying with the Samaja is a bit difficult to countenance when the suit was dismissed, suit itself was dismissed, and the said suit was not a representative suit. Was it representative suit?
Application for permission was allowed.
91.
92
is public trust.
But anyway, that application was allowed. Then suit was disposed of on all the points, including that it is not maintained.
No, whether the application for treating it as representative suit was granted.
Yes, the idea was allowed. Permission was granted.
Okay.
This is as such, I am looking into the present application. IA is allowed, and the permission to issue the suit can be granted. As such, IA is allowed, and the permission to issue.
Then it binds you also.
Yes. And
Because it's a representative suit. It's a suit almost in a realm. It's a representative suit.
All the 11 dependents of the trustee.
Whether all their defendants are not, a representative suit almost operates as a judgment in rem. Therefore, I say a representative suit. There are two division bench judgments of this court. Years I may not be able to mention. There are two judgments of this court. One is by Justice Govinda Bhatt. Another is by Justice Narayana Pai. They have held a decree passed in a representative suit operates almost like a judgment in rem. Means this argument is not available to you. A judgment in rem means it operates as res judicata to the world at large. So traditionally, res judicata is between the parties. If you read section 11 of CPC, it is always between the parties or persons claiming under the parties to the decree. Restriction idrinda emerge agate barkali. It was this apart, the application of the plaintiff filed under order 8 rule 91 baralla. A1 ಯಾವ ಆರ್ಡರ್ ಯಾವ ಆರ್ಡರ್ ಯಾವ್ದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಯಾವ ಆರ್ಡರ್ ನಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಇದನ್ನ ಮಾಡಿದ್ದಾರೆ 91 CPC (92) is public suit, public trust. Do you have the judgment? You are good in civil law. No, that is not a representative suit agalla adu. Adu public nuisance and remove madikro suit adu. That's not that's yav order adu. You know, the representative suit ige order 8 order 1 rule 8. Yes, you are right. Okay. It was it was not a representative suit. It was not a representative suit. Although the application filed under section 91 1B of CPC 1908 was favored by the learned trial judge wide order dated? Okay. 23 March 2000. It cannot be with the same. No, date hakkibeda. It cannot be like that. It has to be precede the judgment and the. Who are all parties to the said suit? And what is the effect of dismissal thereof? Need not be much deliberated by this court, lest such a deliberation should imperil the interest of the third respondent hearing, who can work out his remedy in a civil suit. First, next paragraph. Above circumstances, these writ petitions succeed. 7. A writ of certiorari issues quashing the endorsement dated 28/3/2014, whereby the request for renewal of building license was denied, and it is made clear that there was no requirement of any renewal at all, the first building license dated 13/3/2012 being effective till completion of the building itself. Another writ of certiorari shows quashing the endorsement dated 21/8/2015, which resulted into petitioner's name being deleted from the property records and name of the respondent Samaza being loaded in its state. The writ of mandamus also issues directing the respondent corporation to restore name of the petitioner to the property records within a period of 4 weeks, failing which the commissioner shall pay rupees 5,000 per day of delay. First, next paragraph. The observations herein above made would not come in the way of any aggrieved party approaching the civil court and obtaining an appropriate order on merits. Now, no cause. ಅಲ್ಲಿ ಗೋಸಾವಿ ಮಠ ರೆಸ್ಪಾಂಡೆಂಟ್ 3 ಇದೆಯಲ್ಲ ಇವ್ರ ಪಿಟಿಷನ್ ದಲ್ಲಿ ಆ ಹೆಸರು ಹಾಕ್ಬೇಕು, ಸಮಾಜ ಅಂತ ನಾ ಹೇಳಿದೆಲ್ಲ ಅಲ್ಲಿ. ಎಸ್, ಥ್ಯಾಂಕ್ ಯು. ಎಸ್, ಮಾಡೆಲ್ ಪಿಟಿಷನ್ ಬೈಲ ಪಿಟಿಷನ್ ಹೇಳಿದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? ಯು ಶುಡ್ ಅಸಿಸ್ಟ್ ದ ಕೋರ್ಟ್. ಎಲ್ಲ ನೀವು ಅಸಿಸ್ಟ್ ಮಾಡ್ಬೇಕು, ಸೊ ದಟ್ ನಾವು ಇನ್ನೂ ಜಾಸ್ತಿ ಡಿಸ್ಪೋಸಲ್ ಮಾಡಂಗೆ. ಪ್ಯಾನಲ್ ನಲ್ಲಿ ಇರಬಾರ್ದು. ಪ್ಯಾನಲ್ ನಲ್ಲಿ ಇರೋದಿದ್ರೆ ಕೆಲಸ ಮಾಡ್ಬೇಕು. ಹೌದು, ಅದರ್ವೈಸ್ ಹೆಂಗೆ ನಾವು ಕೆಲಸ ಮಾಡೋದು ಹೆಂಗೆ? ನಿಮ್ದು ಸೂಟು ಇದೆಯೇನಾ? ಅದಕ್ಕೆ ಇಂಜೆಕ್ಷನ್ಸ್ ಎಂತಲ್ಲಿ ಅವ್ರೇನೋ ಅಂಬಭವಾನಿ ಇನ್ಸ್ಟಾಲ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ. ಎನಿವೇ ನಿಮ್ದು ಸಹಿತ ಅದ ಕಮ್ಯುನಿಟಿ ಹೌದಾ? Amba Bhavani is one who had given sword to Shivaji, who saved this country.
we will install.
ಅದನ್ನ ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಮಾಡ್ತೇನೆ ನಾನು ಸಬ್ಮಿಷನ್ ಬರ್ಕೊಳ್ಳಿ.
Temple is there constructed.
Learned senior advocate Mr. Jadhav appearing for the respondent Mutt submits that the petitioners in all fairness should install the deity of Amba, Sri Amba Bhavani. And learned advocate appearing for the petitioner trust readily agrees to do the same. First, same after the completion of the temple building is accomplished. ಅದಾದ್ಮೇಲೆ ಕಟ್ಟಬೇಕಲ್ಲ.
Both license is okay. We are laying foundation for temple also, as well as we want the samudaya one.
ಅಲ್ಲ ಇದನ್ನ ಯಾವಾಗ ಮುಗಿಸೋರು ನೀವು? ಟೆಂಪಲ್ ಮುಗಿಸೋರು ಯಾವಾಗ? ಯಾವಾಗ ಅಂದ್ರೆ ಅದನ್ನು 5 ವರ್ಷ ಹಿಡಿತದೆ. ಆಮೇಲೆ ಅಂತಕ್ಕ ಇದನ್ನ ಹೇಳಿ. This reach jurisdiction 227 ಇದೆ. ಹಾಕ್ರಿ ಅದು ಮಾಡಿ ಅಂಬಾ ಭವಾನಿ ಮಾಡಿ. deity. There is one famous judgment with Madras High Court, division bench judgment. The question, I'm telling about Madras High Court judgment. You are coming in the way. The Madras High Court, 2 English judges considered whether a Shudra can become a king of this country or not. The argument one was Alladi Krishna Swami Iyer, the famous member whom Dr. Ambedkar had chosen as the member of drafting committee. The argument of the other side was, what happened if you read history? Because he went up to Tanjavur. The Tanjore paintings is from Shivaji's. And the sambar which you see, it was the cook who used to prepare something, samba. From samba it is derived. If you go to Google, you will find that. There, the Madras High Court said, in this country, even the Ati Shudra can become a king by acquiring the status. It's the famous judgment which we do not read. ILR 1925 Madras, volume 24 or something like that. There's a famous judgment. Entire thing is discussed about the genealogy of Shivaji, whether whom she married in Tanjavur was the princess or not, whether the children born are illegitimate children and therefore they cannot inherit the property. Several aspects relating to Hindu law and old constitutional law have been discussed. See that out of curiosity, one of the excellent judgments. Yes. You invite all public for installation, but you will be doing everything. No, that's all right. For installation of the deities, invite all people. I will record that now, because this is the constitution. I am saying I am structuring the judgment in that way. Anyway, now he is saying you are installing, you are agreeable. The undertaking given by the petitioner trust that the deity shall be installed after inviting all the members of the community is placed on record. All this does justice to everybody. Our bank account to pay madridu. All right. Thank you. Next. All. Yes. Padidara? You have filed already? Served the copy? All. No, continue. Yes. Next. Yes. Others need not wait. This is a very heavy matter. And therefore, 50? 2022 matter. Call in June. We have held the full bench with sitting with Justice Maheshwari. I have held that the 7 days notice is directory. Read that, which is that famous judgment. Therefore, that contention does not help you. Yes. No. First week of June. Yes. First week of June. Yes, next. Now the show is 6. There is a direction. Next week, Hakon. Hakon, the other one date. Yes. Date. 90. Interim order to continue. Yes. I repeat that. 60. Madhuda. Randomous. Mr. Vivek. Yes, brother, what is this matter? The short grievance of the petitioner is against non-issuance of the khata in respect of the subject property, though there is a registered, sale deed dated, registered Nimeshana Hakku Patra. Verify ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತೇನೆ ನಾನು. ಅಲ್ಲಿ ನೋಡಮ್ಮ. The short grievance of the petitioner is as to non-consideration of his representation for issuance of the khata on the basis of Nimeshana Hakku Patra dated 3/3/2012. Well, a copy whereof is at annexure C. H. Copies whereof are produced as annexures. Learned panel counsel on request appearing for the respondents opposes the petition by filing statement of objections. First, the panel counsel, he submits that the petitioners are coming in the way of Allah. Aleno layout again, they are coming in the way of survey of the property concerned, and therefore there is some difficulty in considering the representations. First, counsel for the petitioners assures that the petitioners, his clients, would not in any way come in the exercise. First, next part. In the above circumstances, this writ petition is disposed of, placing on record the assurance of the respondent local body to consider the representations of the petitioners after verifying the genuineness of the documents concerned. First, this exercise to be done within 8 weeks. Okay. Senior advocate is waiting. 50. Repeat that.
Mr. Siddharth Yadav.
Yes.
Mr. Siddharth Yadav.
Please, Your Honor.
Yes, Mr. Yadav. Yes.
Right.
Yes. Now, just give me the date. Mr. Yadav Sahab,
please, sir.
Kindly give me the date under in which the arbitration clause is there.
Yes, that
Yes.
is 24/4/2006, page 186, Annexure H.
Others need not do it.
Annexure H.
ಅಲ್ಲ ನಮ್ಗೆ ನಂಗಾಗ್ತಾ ಇಲ್ಲ ಅವ್ರನ್ನೆಲ್ಲ ಬ್ಲೇಮ್ ಮಾಡಬೇಡಿ. ಐ ಆಮ್ ನಾಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್. Yes, sir.
24/4/2006.
2006. Annex
H. H for Hong Kong. H.
Page number
186.
No, 214 alva. Is it not 214?
That is the typed copy, and what my lord is correct in 214 is the Article 11. Article 11 pertains to the arbitration clause.
186 is original.
186 is original, and the
clause
Article 11 at 214.
Article 11.
Which talks about appointment of a an arbitrator, it says. Not a panel, an arbitrator. So sole arbitrator.
Sure, just show me.
Please, kindly have page 186 and then 214. My lord is absolutely right about 214. Now, while I'm on 186, I just beg to place one fact on record, my lord, if my lord kindly permits me. 186, my lord has, I wanted to only show one fact. My lord sees, this is a joint venture entered at Bangalore on 24th of April 2006 between Messrs. Bharat Infra Tech Limited, so-and-so, represented by its chairman, Mr. Dayananda. My lord has seen that.
One second. Article 11 is where it is?
214. 214. 214.
Four.
11.2. In the event the parties are unable to resolve their disputes or by conciliation as above or within such time frame as the parties may mutually agree, the dispute may be referred to an arbitrator. In a
sole arbitrator.
Sole arbitration, please.
In Bangalore City.
In Bangalore City. So my lord had on the last occasion put to my learned friend he had said that he will get back on either of the two options. One, if his parties are agreeable to settle. If not, appointment of an arbitrator. So I'm agreeable. My lord, if party suggests, then obviously the one party may have an objection to the other. I am agreeable to anybody my lord appoints.
Answer. Let us see. Yes. Sole arbitrator. Who are the parties to this agreement?
Yes. Now I wanted to show that. Please kindly see 186. Kindly just see 186. That's
186.
186. For completion of submission, I wanted to invite my lord to see joint venture agreement, Kolamangalam project. This agreement is entered at Bangalore on 24th April 2006 between Bharat Infratech Private Limited, Company Incorporated under Companies Act, at so-and-so, represented by its chairman, kindly mark Dayananda.
Chairman, Mr. Dayananda.
Mr. Dayananda and Mr. Hanuj Singh, resident of so-and-so DLF phase 4, Gurgaon, Haryana, referred herein as investor. And Gold City Developer, a company incorporated under the Companies Act, registered office at so-and-so, Gold Tower Residency, Bangalore, represented by Mr. Hanuj Singh and Chetan P. Tayal. My lord has noted Chetan P. Tayal there.
That Gold City Builders is represented by Anuj Singh
and
Chetan P. Tayal.
Tayal. Correct. Now, kindly turn the page. Now, if my lord was to read with me the fourth paragraph on 187.
Mr. Anuj Singh.
Mr. Anuj Singh and his associates, hereinafter collectively referred to as investors interested in to venture into real estate market in India, including hotel and service apartments, residential, commercial complex, have offered to purchase 49% interest in the scheduled property and thereafter develop and run the service apartment jointly with BITPL, and BITPL has agreed to accept the offer. BITPL is respond number 1. And Gold City is respond number 2 before my lord. And whereas parties agreed to collaborate with one another in accordance with the terms hereof for the purpose of to operate through instrumentality of a joint venture company.
1 second.
Please.
BITPL is R1.
Number 1, R1. Duly represented. Yes, I read further.
And Gold City is?
Respond number 2. R2.
R2. This is filed by
me. I have filed.
Any Lachman Mathan Anuj Singh. Petitioner 2 is there.
Yes. I have filed this.
Who is Heni Lachman Mathani?
He is the chairman director of the Platinum Investors, and I'll come to that. He is the one who made the first payment. I'll come to that. Just allow me a moment. I'll come to that. For completion, can I read this and then I'll come to that? Yes. Bottom paragraph. And whereas parties agreed to collaborate with one another in accordance with the terms hereof and for the purpose to operate through the instrumentality of a joint venture company incorporated under the Companies Act of India under the name and style Gold City Builders and Developers Bangalore, hereinafter the JVC, which is R2. Whereas BITPL will enter into a joint development agreement, which is the JDA, with the JVC as per Annexure 2 in order to develop the project herein, wherein the JVC shall have 90% of right, title and interest, and BITPL shall have 10% of the right, title and interest in the project upon fully developing the property in residential, service apartment and commercial complex as per plans approved. Whereas
Mr. Yadav, you do not take me to that depth. You have to show me existence of arbitral clause which binds the parties.
Yes.
Existence of dispute or difference.
Yes.
And section 21 notice. Because section 11
because
therefore we need not delve into that depth at all.
So great.
That you have to show to us.
So I am only for the purpose, because they have raised a doubt vis-a-vis the parties. I have shown now, my lord, the parties. Kindly come to the first document which the parties executed at page 150.
150.
Yes, 150. This is the first document, the MOU.
This is between?
Again, respond number 1 and Mr. Heni Mathani's company, Platinum, the first investor. This is dated 31 March 2006, prior in date to the JVC. I need not trouble my lord with the depth of the document, only the opening recitals. This memorandum of understanding.
This is between?
Respond number 1. And company of petitioner number 1, which now stands dissolved, and he has taken over all the entire 100% shareholding has gone to him.
petitioner number 1.
Henny Mathani.
Company of petitioner number 1 now.
Company
Means
of,
what? Company is different on this.
No, my lord, what happened is the company stood dissolved. This was his family company between him, his father, and his brother. The company, after this document in 2009, comes to be dissolved.
Dissolved by how? How it came to be dissolved?
Hello, it's a Hong Kong-based company. Platinum Realities is a Hong Kong-based company. It gets dissolved. They say that all assets and liabilities of the company go on to Henny Mathani. There's a document on the record to that. He is one of the investors, and I'll show the list of investors also. Allow me to just show 2 documents, and I'll satisfy everything, every query of my lord.
No, not like that. One second. You have to clear the doubt now.
Please.
How Mr. Henny Lakshman Mathani is not one of the parties to the agreement, the arbitral clause.
He is one of the list of investors. Yes, the list
of investors is furnished where?
Page 157.
157.
Annexure G.
So this platinum is having been dissolved. All its assets and liabilities are taken over by petitioner number 1.
Absolutely correct.
Yes.
My lord had put to me the list of investors, 157 I'm showing. Each of the investors. I have already shown the document which says Hanuj Singh on himself, on his behalf and behalf of the investors. The entire list is there. My lord sees the left-hand side, the column. My lord has the left-hand side column.
Page number 157.
7. Annexure G. The first name, Pankaj Rishi, my lord sees first name.
Is it a part of Annexure F? No, it's independent document.
Independent document. Annexure G.
Yeah, I got it. Last time also we deliberated on this lot, no?
Correct. Absolutely right. My lord is absolutely correct.
But it is not part of Annexure F. It's an independent document.
It's an independent document.
They invested the money.
Now I want to show, my lord sees left hand side the column Pankaj Rishi.
Correct.
First name.
Pankaj Rishi.
That is petitioner number 4. Mig Dadlani, petitioner number 5. Jiten Mansukh Radia, petitioner number 6.
So all investors happen to be the petitioners.
They have independently also filed a petition. Correct. So they have come before my lord saying that I want to raise my grievance. I have given my money. Money has been usurped by the respondents. Kindly refer my dispute to arbitration. I am showing proof of my investment, and I have entered into the agreement with respondent number 1 and 2 through the parent investor Hanuj Singh. Now that is settled law. There is no dispute. Supreme Court Cloro, my lord, Justice Chandrachud, Justice Khanvilkar judgment are very clear on this. I will place those judgment on record. That one party as an investor, the lead, can represent all of the others and request for a reference to the disputes to arbitration. That has been referred by the additional district judge in the section 9 petition also. That order stands confirmed, not challenged till date.
So all those investors automatically can seek refuse under the arbitration clause is your version.
All the investors can.
All the investors.
Yes.
They can invoke arbitration clause.
Correct. They can.
How that arbitration clause is worded? Just show me.
He's come. Kindly come.
To page 214.
214. This is before that, my lord has seen that all investors are mentioned. When Hanuj Singh signs this agreement, he represents the investors, the entire list of investors. 186 and 187 repeated.
H dated 24/4/2006.
Correct. Now, when Hanuj Singh mentioned, it mentioned
between
the he's not himself. He's not only for himself. He is for himself and investor. Please turn the page. 187.
Yes, I'm just making notes. No.
Sorry.
Between the first respondent, BIDL, and Platinum Realtors, which is now dissolved, and its assets and liabilities have been taken over by the first petitioner, Mr. Henny, H-E-N-Y. Or and correct. The second petitioner, Hanut Singh, happens to be the lead investor. Alva. HG.
And representing all the investors in the joint venture.
Represents all the investors.
As per the JVC.
As per
joint venture agreement.
Joint venture agreement dated
24/4/2006.
24/4/2006. The arbitration clause is found at Article 11, page 214. No,
absolutely
215.
Right. 214. Starts at 214, goes to 215.
214-215. What is Annexure F 31/3/2006?
Annexure
Memorandum of Understanding.
Yes, my lord, that's the first. My lord, when these parties met, they discussed. That's the first document executed by virtue of which the understanding was arrived. Memorandum of understanding was arrived between the parties where we will collectively do business. Under that first payment, under that 50 lakh payment was given. First 50 lakh payment was given to R1. 50 lakhs under this.
Next paragraph.
First payment of 50 lakhs.
Memorandum of Understanding dated 31/3/2006 at Annexure F 150. F bracket dash 150. 150. He is between first respondent and Platinum Realtors Limited, which having been wound up, the assets and liabilities are taken over by the first petitioner, Henny. So, BITPL, no, BITPL is no, Platinum. Only two parties here.
See, correct. This is the JV MOU. This
follows. It provides for investment also pursuant to Annexure H.
This is predecessor.
Prior to that.
No, prior. This is prior. This is 31st March 2006.
You are right. It's prior to that.
So first document
this provides for investment.
Well, correct. So what I'll explain. You just allow me a minute. Parties come together, Platinum and Bharat Infratech. They agree to get into this understanding. under which Platinum pays 50 lakh rupees, first investment of 50 lakh rupees to Bharat Infratech. The entire deal is struck for 8 crores. That I have to pay you 8 crores. I will get 49% in the joint venture agreement, which following this is the joint venture, which Hanuj Singh executes.
Whether one second, whether Annexure H mentions about Annexure F?
Yes.
Where is
Everything.
that?
Yes.
Just show me. This memorandum of this MOU figures in joint venture agreement. Which paragraph?
Yes, I will just show to my lord. My lord sees article page 191 onwards. The investments.
Where is that? Does it refer to? It does not.
I don't know. I'll just show exact line. Exact line I will show. My lord.
Yes. To 187 last paragraph. Last but one.
Correct, my lord. Absolutely right. Absolutely right. So grateful.
187. To the instrumentality of joint venture company incorporated under the Companies Act 19 under the Gold City Builders, so and so, so and so. Huh? In fact, investors shall subscribe an amount of rupees 8 crore.
Yes.
188.
Correct, 188. Investors. Which amount shall be paid to JVC, to BITPL, which is respond number 1, and JVC, which is respond number 2, shall allot so and so shares to BITPL.
MOU in substance figures in the JVA. JVC na JVN na JVC.
This is JVC. This is
JVC and what is that JVC?
Joint venture.
JVA. JVA. Pages.
Joint venture agreement, and the respond number 2 is called JVC, which is joint venture company.
Oh, it's called a joint venture company.
Respond number 2 is called
joint venture JVA
and JVA.
At pages 187 and 188. ಇದು ಈ ರೀತಿ ಪಾರ್ಟ್ ಹಿಯರಿಂಗ್ ಆಗಬಾರ್ದು. ಇದು ತಗೊಂಡು ಕಂಪ್ಲೀಟ್ಲಿ ಮುಗಿಸ್ಬೇಕು ನಾವು. ಇವು ಎಲ್ಲ 25 ಕೇಸ್ ನಾವು ಹಾಕೊಂಡ್ಬಿಟ್ಟು ಭಾರಿ ಸಮಸ್ಯೆ. ಇಟ್ಸ್ ಅ ಹೆವಿ ಮ್ಯಾಟರ್. What is this 25/5/2006?
So grateful, my lord. I was coming to that document. That is, my lord.
What is that?
Yes. Can I explain? Can I
Yes.
explain? My lord, first document is the MOU which I have shown to my lord, 31.3. Follows where 50 lakh is paid. After which, as per the understanding, the JVA is entered between the respondents and the investors. Following which, now the JDA for development of this property, where it was to be constructed. This is the registered document between respond number 1 and respond number 2. And also on the same date, they execute annexure K, which is the joint real power of attorney, registered document again. Same date. Page 260. On same date, 2 documents are executed, both registered.
Do they mention about JVA?
No, they don't.
They don't.
But how I'm drawing my lord, no, section 114 Evidence Act, how I'm relying on that. In this follows the entire development pattern. The language is verbatim JVC, and this document has been witnessed by Hanuj Singh. He stands witness before the sub-registrar's office. Please see that registered document at page 244. By which they agreed that they will allow respond number 1 will allow respond number 2 to develop this project from the money which I have paid.
Where is it mentioned?
Sorry?
Where is that mentioned?
No. My lord, that's what the JVC says. JVC refers explicitly about JDA. I was showing to my lord the JVC, which explicitly mentions about joint development agreement. And that is this joint development agreement. That's why the inference from 114. The facts clearly show that money is through me, development, and then the request for arbitration. They failed to do anything with my money.
Yes. Yes, sir. Let us see what he will say. Yes.
Now, my lord, just can I complete? Can I? Before my learned friend starts, just 1 minute. I want to show just one fact. My lord has seen 3 names.
Yes.
Dayananda, Chetan Tayal, and Gold City and Bharat Infratech. These are the names which have come before my lord. Kindly just have my rejoinder for a moment, just for a moment.
What you want to show by that?
I want to show.
Then you take me through that.
I want to show. I won't take my lord. I want to show all these people were directors of the company at the relevant time, or which my learned friend did, because their contention is that they refute the execution of the documents. Their main contention is that all these people were at the relevant time directors of the company in respond number 1 and respond number 2, and have resigned subsequently after the execution and then after the filing of my petition under section 9. It shows their collusion in the manner of breaching the agreement with me and thereafter terminating the contract. There is a termination agreement which they have filed that the JDA stands cancelled. I am trying to impress upon my lord that respond number 1 and 2 are not different. They are two sides of the same coin, acting hand in glove. Today, to show that there is no agreement subsisting between respond number 1 and 2, and it stands terminated, the JDA, the registered document. So therefore, I should be read remediless. Is it, according to me, in respectful submission, a faulty argument? For the reason I am only to show to my lord the existence of an arbitration. All these aspects are to be a matter of evidence, trial before the learned arbitrator. That's the request I'm making. Subject, I'll satisfy whatever. I'll come to whatever my lord puts to me.
Yeah.
Still, like what this is also wants as easy as that. Because court has to refer parties to arbitration. Is that the dispute proceeding there were parties for self-arbitration. Except petitioner number 2 and argument. All others do not have an argument. And by substitution or by showing some amount or by saying that these persons are probable witnesses, they can't be embraced in that. This is direct method of achieving something which they do not have achieved. But extent, all the petitioners are non-suited. Except perhaps P2. But
Annexing.
But P2 also. By virtue of pleadings in paragraph 15 of the CM, also is non-suited because what P2 is portraying is a corrective dispute between P2 and P1 to 20. Says that the dispute rests between me and P1 to P20 and R1 and R2. Then this entire dispute has to go out of the court of law. It has to be settled with the. Can you see that clearly? The dispute that is projected to be decided, such a dispute is out of the scope of arbitration. Because what P2 says is a mixed cause of action between entire petitioners and R1.
Where have you taken up your objection that way?
My objection, I have said that I have not entered into this agreement at all. But my view is that on the point of that it is not an arbitrary, because it has to qualify within section. That one your lordship should find para 15 of the bill.
Of your SO?
Yes, yes. No, all the petitions.
ನಿಮ್ಮ SO ಎಲ್ಲಿದೆ? ಕೊಡಿ. ಎಲ್ಲಿದೆ? SO ಹಾಕಿಲ್ವಾ? ನಮ್ ಕೊಡಿ. SO ಇದೆಯಲ್ಲ. Now, if you have taken up such a contention, then you can structure it. If you have not taken up that contention, perhaps you cannot, because your case is that there is no such agreement at all. Therefore, no scope for such argument at all. Yes. ಇಲ್ಲ. 15 TMB.
This is the fourth first of the district. The feeling that how the other petitioners are involved in this dispute and what is the nature of the dispute.
Whereas
page 32, ends it as is clear in the big. Hence, as is clear from the petitioner to subscribe an amount to pay in respect of in respondent, which amount was to be paid by respondent number 2 to respondent, and the respondent number 2 was to allot 6.70 lakhs to respondent number 2, which was to
respondent number 1 all. Two paid by respondent number 2 to respondent.
2 will allot, 2 will pay this money to 1, and 1 will allot equity shares to respondent number 2, which was to be equal to 41% shares in RT towards part and sale consideration for the value of the settlement in terms of the JVA. Simultaneously, it was agreed that respondent number 2 shall allot equity shares equivalent to 8 crore to petitioners against the investment value which was to be equivalent to 49% sharing in respondent number 2 of the deed. Therefore, this dispute, this is the core dispute. This dispute is with petitioners. It is not with petitioner number 2 alone. And their cases, all these petitioners in some have invested 8 crores. In such circumstances, if cause of action is made out by all the petitioners, or a list is made out by all the petitioners,
yes,
and only one is a part, it is not distinguished between the petitioners. What is the dispute exactly between petitioner number 2 and Arvind? Then the entire sum and substance of this will have to go before a single authority, which is the civil court. Therefore, question of arbitrability
yes
is the second issue is that whatever is produced at page 57 is a statement of money paid. Yes. Let us say they say that certain amounts have been paid. That is a statement of money paid. In that announcing petitioner number 2, there is no statement of any money paid by petitioner number 2.
Now, do you dispute the money received by you? What money?
I am the presenter. I went to the bank and the bank has 2 objections. One is they say that accounts prior to 2013 will not be able to. Second is what the bank says that the then directors themselves must come and give a letter of no objection from the first.
What is your stand in your statement of objections as to receipt of the money?
My objections have been denied.
You have denied, but that has been paid by bank drafts.
This, of course, they say today I am not in a position to verify because I don't have those accounts. Therefore, I am not in a position to confirm those figures. That's why last time I asked them, kindly provide those accounts. But in any case, assuming that such payments were made by third parties, were made as per page 1. But what is the contract I have with those parties? Suppose I have no contract with the parties and no agreement is there for arbitration, then they have to work out their rights to put another forum. It is not that they have lost the forum. The forum where they come before the court, forum where they come, they must back it with the arbitration. Therefore, under these circumstances, the pays those persons who are paid, if you are not going to see, all those persons who are paid, petitioner number 2 is not a pay. All the other persons who are the petitioners who are paid, they are not parties to the arbitration. And if at all this has to be decided, vis-a-vis these payments, because 157 makes it very clear that these recoveries cannot be through arbitration. If at all it is their claim that they make.
Short written submission equity.
Just 2 other points. On the ground of misjoinder it should take. And further, the JVS limit is not stand.
That is considered by the apex court, na? What and they said you act upon the document. They said even that aspect can be pressed into service before the arbitrators.
And regarding non-production of business, there is no judgment of
Correct.
original agreement.
ಅದ ನೀವು ಈಗ ಪಿಟಿಷನ್ ರೆಡಿ ಮಾಡಿ ಕೊಡುವಾಗ ನಿಮ್ಮ ಪ್ರಪೋಸಿಷನ್ಸ್ ಆಫ್ ಲಾ, ಸೈಟೇಷನ್ಸ್ ಅಂಡ್ ಮಟೀರಿಯಲ್ ವಿಚ್ ಯು ಡ್ರಾ ಫ್ರಮ್ ದಿ ಪ್ಲೀಡಿಂಗ್ಸ್ ಆ ರೀತಿ ಮಾಡ್ಕೊಂಡು ಒಂದು ಇದನ್ನ ಹಾಕಿಬಿಟ್ಬಿಡಿ. ಐ ವಿಲ್ ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಮಂಡೇ. ಜಸ್ಟ್ ಯು ಫೈಲ್ ಯುವರ್, ಯು ಆಲ್ಸೋ ಫೈಲ್ ಯುವರ್ ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್. ಲೆಟ್ ದೆಮ್ ಬಿ ವೆರಿ ಬ್ರೀಫ್ so that from that I should be able to structure my judgment. Yes. Unmute.
Manoj, can I request instead of Monday, Tuesday, please?
All right, Tuesday.
Manoj, will you keep this matter for hearing on Tuesday, or we'll just take it?
No, I'll keep it for hearing, because in the meanwhile I'll also go through. If there is any confusion, I can get it clarified from both of that.
Very well. So,
yes. And propositions now you have taken up. You have to meet those propositions so that I will be in a position to understand your viewpoint by looking to your written version. Brief argument it should be. It should refer to concerned pages of the pleadings and documents.
Only my learned friend. Anita, will you take this copy with them?
That the word investor could mean every other person who is not part of it. This is unacceptable. At least I'm putting on that learned senior counsel. That this is unacceptable. That would mean throwing open the Pandora's box under the name of investors, giving parties or persons who have no arbitration agreements and trusting them with arbitration. That is not possible. That is what learned senior counsel appeared to say.
What court's view is on this point?
No, because it is only on the basis of if there is an agreement in place.
No, that I have understood. It's so simple. But how courts have structured this argument? Adunu ready marking. All this matter on Tuesday.
On Tuesday? My Lord, can you have it in the first half itself? Can my Lord have it in the first half?
Perhaps yes, perhaps subject to availability of our leader of the bar. He has tremendous work pressure. Apart from these cases, he has assumed an office which generally would put everybody to diabetes or some. Of course, quite strong. Genetically, he is strong. His father was also a permanent president of our association, right from the days of Anglo-Saxons.
Oh, wonderful. So, my Lord will have it in the first half only, not in the first half on Tuesday. On Tuesday. My Lord, and my
instructing counsel ಅದು reach out, he will send. I will send words to you.
My Lord, whatever citations they have referred to, if they can share with my colleague, we will also refer to those judgments then.
You please give your phone number so that I will introduce my closest friend to you, Mr. Vivek Reddy. He's a very strong advocate, very nice gentleman. Yes. And you will be his guard of honor when you visit Bangalore.
My pleasure.
As he will be when he visits your place.
Anytime, my Lord, it will be a pleasure.
Yes,
So,
yes, Vivek, your number kadi.
Yes, my Lord, because Miss Anita will take the.
Yes, I will get it from.
I will get it. Yes,
yes.
Madam Anita will speak to you.
Tuesday. Thank you. Thank you, ma'am.
If there is any difficulty, I will like. 16. I also scored. That would have created some difficulty, perhaps. But let us see. Honorable Chief Justice also has looked into that.
ಒಳ್ಳೆ